Let's begin. Well, I'm sure you're going to have a superb, timely, and interesting program ahead of you today. I was somewhat surprised by what a buzz there was in the lobby as I came in the elevators amongst our students. I'm glad to see many of them here. But they were all asking me whether I was heading to this program. And I said, do you have any idea or concept of what this program is about? And one of the fellows leaned over to me and said, one word, heuristics. So they obviously do, right? So when I was in the process of becoming the dean here, my name is Nick Allard, I was often asked about the so-called balance between practical training and the scholarly mission of law schools. And I was pressed to ask whether I thought the balance was right and whether, more emphasis should be shifted to practical training in light of the job market and the economy. I don't think it was actually a friendly question whenever that was asked. But I resisted, and I truly believe that that's a false choice and that you have to do both. And the reason for that is that we do owe an obligation to our students and to the legal community and to the clients of the future to produce people when they graduate who know what they're doing. And we do. Brooklyn Law School has always had a reputation for doing that superbly well. But it's precisely because 96.7% of our graduates, by the way, all statistics are made up on the spot for the purpose of argument, 96.7% or so of our graduates will not be academics, will not be in an academic community, that this JD is their terminal degree, and it's the last time that they are part of a community of scholars. And so our aspiration for them is not just to know what they're doing and be top in their field when they graduate, but to equip them with the critical thinking and learning skills, the intellectual capacity to answer questions that nobody's seen before, and to be leaders in the future and help steer the profession as we go around the corner. And so I think that this conference is a wonderful, emblematic example of that concept, because it blends the critically important practical skill of writing, which we have always, under the leadership of our Director of Legal Writing, Marilyn Walters, done well, if not better, than any other of our rival institutions, and I hope that I'll be forgiven some of that hubris and pride in place. But it also is taking the most practical of legal skills, which is writing, and addresses it from an intensely intellectual and scholarly perspective. I have said repeatedly recently, and when I say this, I often get a gobsmacked response. I say that in terms of our future at this law school, our aspiration is not to be better. And then I take a 10 count and people look at me. And I say that our aspiration is to be the very best in the things we can do best and do uniquely well. And again, this program today is an example of that. We not only have a signature writing program, led by Marilyn Walters and with the help of many, including Betsy Fagins, who have worked, they've told me, for 18 months to put this program together today, but really this program embodies, for these young ladies, probably over 50 years of experience in the field, and it reflects their thinking and work over a great span of time. But it also is a field which Larry Solon, who is going to be with us virtually today, I understand. He's probably in Bora Bora or something, but he'll be with us virtually today. It's something that we have carved out a true, strong intellectual niche, and that is of cognition. And he heads up our law, policy, and cognition program, and we've had very recently some incredible programs addressing issues in that field. And finally, here's a thought. The first information technology was oral expression, speaking. The very second was writing. The ability to convey your thoughts in writing and be able to share them in a non-contemporaneous form. And so the issues that we're addressing today have two aspects to them. They're timeless, in a sense, because many of these issues that we're addressing today are ones that have been debated since the advent of writing. In fact, there's a wonderful article that Georgia Nugent, who was a classicist at Princeton and is the soon-to-retire president of Kenyon College, wrote called "If Socrates Had Email." And so Socrates was very concerned about this new proliferating technology of writing. His concerns were that when that your students will be focusing and looking down on their papyrus instead of paying attention in class, that it could be misinterpreted, that the messages were squirrely and private and not open to the community, and that they were also subject to being intercepted, and that private communications would be compromised. Sound familiar? So, in a sense, the issues that are being addressed today, nobody's particularly worked out solutions to these questions, but they're timeless. They're also unique in another way, and that is that the question of cognitive bias involving an information technology, writing, is one that is uniquely a question or issue of humans. And although I think that my friends like Professor Larry Lessig at Harvard or Professor Jonathan Askin might disagree with the conceit that cognitive bias is uniquely a human condition and not something that is not experienced by supercomputers and highly intelligent computer software. Let's all just pretend today and enjoy the conceit that this issue today is something that we humans share and are addressing. So I'm sure you're going to have a wonderful experience today. I hope that this is interactive. I particularly want to welcome back our Professor Medved, who has not only had a distinguished career as he's moved on, but while he was here was voted best teacher. And so it's great to see him back and participating in this panel. I don't mean to slight any of our other distinguished panelists. It's a wonderful program. I congratulate the organizers. I thank Larry Solon. And in particular, I congratulate and look forward to reading the proceedings in our Journal of Law and Policy, and for the students who will be producing that. That's a very important aspect of this program, in that the proceedings will be memorialized and then shared, and I hope that there's not too much cognitive bias when people read the proceedings a few months from now. Congratulations, thanks, and I'll ask Professor Walters to kick this off now.
Thank you, Dean Allard. I want to welcome all of you here as well, and note that you have the biographies of all of the speakers on the chair that you're sitting in, and so I'm not going to describe their considerable achievements, but leave them to you to read at your leisure. I'd like to introduce our keynote speaker, Professor Larry Solon of Brooklyn Law School. He is going to be talking with us from California, and I will, with my fingers crossed, sit down and wait for him to begin. His presentation is entitled 4 Reasons to Teach Psychology to Legal Writing Students.
All right, Larry, we're ready to go.
Well, thank you. People hear me?
Yes. Yes.
It's a great experience. Before I start talking about the substance of my talk, I want to say something. Over the past month or two, people have been finding out about this conference through its being publicized on SSR and the like. And because it's co-sponsored by the center that I'm the director of, people have been giving me credit for this. And you get blamed for things you didn't do wrong enough that sometimes it feels sort of as rough justice to get credit for things that you didn't do right. But the real credit for this entire conference and the idea behind it goes to Marilyn Walter and Betsy Fajan. It's one of those things like the literature on cognitive biases and heuristics. One would think that seems so natural that somebody should have thought of it before, but nobody did, and that's why Kahneman won a Nobel Prize for it. And it's I don't think Marilyn and Betsy are going to get a second Nobel Prize, but it's really just a wonderful idea as far as legal education is concerned, and I'm very proud to be part of this. It's also pretty cool to be thousands of miles away and to be giving a talk like this and seeing, I see, my own law school feels great to be connected, at least this much. So what I'm going to do now is there's a device which allows me to present to see a PowerPoint screen on my computer, and for you to see what I'm seeing. And I'm going to do that now. It's going to take about a second. Oh. I'm so sorry. This will just take a second. Do you see it?
Not yet.
Okay, it'll take. We did it before. We'll do it again. How about now?
We're getting there. Yep, we're up. Thank you.
Terrific. But that's about as good as I am with technology. It wasn't that terrible. Well, what I want to talk today about is are some cognitive, some heuristics and biases that I think will be useful for legal writing students to know about. And with some luck, this will overlap with some of what will be spoken about later in this conference. The first point that I want to make is that everybody's subject to these biases, and this includes the student who will soon become the lawyer, the client, the boss, and even the judge. But the judges don't always go to humility school, so one needs to write in such a way that the judge will appreciate what you're writing without their feeling that there's any condescension to it. The four reasons are not these four audiences. There are really four reasons, each of which applies to all four audiences. So there are 16 reasons for teaching teaching about heuristics and biases to legal writing students. Now, here's what I think should be the takeaway from the project that again Marilyn and Betsy suggest. First, students should learn to overcome their own blind spots and biases so that they do not become victim to them. And second, they should recognize the biases of their intended audience so they can overcome predispositions against their position that are not based solely on the merits of what they say, or subject to ethical concerns take advantage of the predispositions in favor of their position about which audiences may not even be aware. I think that this second point is really of some complicated significance, because lots of times lawyers are very good, and the most skilled lawyers are excellent at determining what it is that will push buttons in the audiences that they have and to play into this. Within ethical constraints, I think it's a very good idea to be train our new lawyers, that namely one else, to become the next generation of the best lawyers. So that's sort of the mission of this talk. And the four examples that I'm going to give from the psychological literature and present you with, including we're going to all be doing some experiments together, are to write simply, to watch out for the confirmation bias in yourself and others, to realize that we tend to explain people's conduct as a result of their character, to discount circumstances, defend against or exploit this fact as you wish. That, incidentally, is called the correspondence bias, and in the older literature, it is called the fundamental attribution error. And fourthly, to recognize that we are blind to our own biases and learn how to overcome the bias blind spot. So I'm going to talk about each of these, but before I do, I'd like to say that the literature on cognitive bias is really called the literature on heuristics and bias. And the heuristics part is often left out because it's a little less sexy. It's very important to remember it. The whole premise behind all of this is that we use intellectual shortcuts very, very successfully in our lives to simulate rational thought. That is, we have a system in which we are able to make pretty good, quick judgments about things that are very important, but we don't make them by pondering. And the result is that we're able to get through our lives with a certain level of efficiency. But the downside is that these strategies cause us to make systematic errors sort of in the corners of our lives, and those errors are exploitable in ourselves and others. So we're going to talk about the biases, but the biases are the flip side of a lifestyle in which we are really very successful. That part is all too often ignored. So now I'm going to first talk about simple writing. And this material comes from a psychologist named Daniel Oppenheimer. So here's what Oppenheimer does. He has a whole bunch of experiments in which he gives people two versions of a text and asks them a bunch of questions. One of them is, which one's written more simply? People get that right almost all the time. But another one is to rate the intelligence of the author. So I'm going to give you an example. I think there are two translations of a Descartes meditation, which you've probably never read, and which is what he wanted. And this is one of them. It's the simple one. And by simple writing, he used a criterion of not using too many big words. That was the only criterion. Here's the one that's more complicated. These are both actual translations. It's okay if you don't finish them. The legal writing faculty sitting there are probably cringing at this. You didn't have to write that way. Okay. Now students participated in the study which half read version 1 and half read version 2, and half within each group were told that the author was Descartes, and the other half were told that the author was anonymous. They were asked to rate the intelligence on a 1 to 7 scale, and here's the result. Even when you knew it was Descartes, they thought that Descartes was smarter on a 1 to 7 scale when he wrote more simply. They gave him about a 6.5 out of 7 on the simple version, or the simpler version, and about a 5.5 out of 7 on the more complex version. And when you didn't know who it was, they obviously they thought that person was less intelligent and told him it was a famous philosopher. But again, the simple translation was better than they thought it was smarter than the more complex translation. So the takeaway for law students, if you look smarter when you express your thoughts in language that everyone can understand. Now, I can't imagine that writing faculty are drilling this into students anyway. But there's such a tendency to try to show that you're a little more intelligent by writing a little more complexly, that pointing out experiments of this sort to the students can reduce the extent to which the writing faculty are acting as authority figures and to increase the extent to which the writing faculty are sharing learning with the students and in a team effort to try to accomplish this task. So it may have value in that respect. The second one, we're moving through these pretty quickly because of time. The second one is called the confirmation bias. And there's a line from the boxer. This is a very famous experiment by somebody named Persuasion. Suppose each card has a number on one side and a letter on the other. Which of these cards are worth turning over if you want to know whether the statement below is false? The statement is if a card has a vowel on one side and it has an even number on the other side. So I can't see, I'm not going to ask people to raise their hands, and I can't see it anyway. You can see me, but I can't see you right now. But clearly you want to turn over the A, because if there's an odd number on the other side, it would disconfirm the hypothesis on the bottom. You don't want to turn over a D. But when given this test, a lot of people initially think you should want to turn over the 4, which is incorrect. And they don't know that you should turn over the 7, which is correct. The reason the 7 is correct is because if the 7 has a consonant on the other side, it really doesn't make any difference. But if it has a vowel on the other side, it's disconfirmed. And people have trouble looking at evidence that can only disconfirm. You can't confirm the hypothesis of the 7, but you can disconfirm it. And people simply don't look at the world that way as easily as they look at these A's, confirmatory pieces of evidence. This is important because there's nothing political about it. It's not that, that you like to watch MSNBC if you're a Democrat or Fox News if you're a Republican. It's that those tendencies emanate from this particular cognitive bias that we have. And now here's a study that was done by my friend and writing partner, John Darley. This picture was not part of the experiment. They showed a film of a girl taking a standardized test, and in one version of the film, she was in a setting that made it quite clear she was from a low socioeconomic background. But it was the same girl in the same film. And she was wearing a headset. So they would tell her to look up, put your pen in your mouth, look down, write, so on. Then they did the same thing with somebody who looked like she was in a wealthy school setting. And then they asked people how they thought she was doing on the test, and the answer was that they thought that she was doing much better when they thought she was a rich girl than when they thought she was a poor girl. So they confirmed their biases that when she was looking up, when they thought she was well to do, they said, oh, this is a wonderful student. She thinks before she writes. Try to teach people to do that. But when she was a poor student, she said, oh my God, she has trouble concentrating. Maybe she should be on medication. It's exactly the same film. So the takeaway here is we tend to pay too much attention to evidence that confirms our position and not enough potentially disconfirming evidence. In an adversarial system, this can be a devastating mistake. And I know this again is taught, but if it's taught with respect, and if the psychology underlying that these insights is introduced, perhaps the students it will resonate even better with the students. Third, I'm going to mention what's called the correspondence bias, which is that we pay too much attention to character and not enough attention to circumstances. And here's a quote from a leading paper called The Correspondence Bias, for that matter, by Dan Gilbert and a colleague of his. Here's another study from John Darley and another colleague of his named Viv Latney. A student participating in an experiment is listening to another participant over headphones as he sits alone in a room. He hears the person who is speaking to him suffer an epileptic seizure. It was a simulated seizure. that if there's any problem during the experiment, you should contact the monitor outside the room in the corridor. Does not advise the monitor upon hearing the person suffering the seizure. What do you think of him? Well, you would think this is terrible. He's so tied up in being obedient to the experimental setting that he doesn't even have the decency to report that somebody's having a very serious medical problem. But here, let me tell you a little bit more about the circumstance. When the participant quote, he was one of 6 participants, less than a third of the people did this. But when they thought they were the only one other than the person suffering the seizure, 7 out of 8 reported it. So how likely we are to report as a bystander that something terrible is happening has to do specifically with the situation in which we find ourselves. When you know that and you hear that it was one of 6, you will not think as poorly of him as you did before you knew this information. That reflects what's called a correspondence bias. That your tendency is not to pay adequate attention to the circumstance or ask questions of the circumstance, but rather to attribute behavior to character. And it's quite clear what the takeaway of this is. Anybody who's a good negligence lawyer knows that if you can pound the character of the defendant, you have a better likelihood of getting a good verdict for your client. So, and then similarly, if you have a client who's not a very sympathetic person but might not have done something wrong, this bias is very, very important, and one must present information in such a way as to overcome it, or your client's going to get a worse result than the facts of the case should cause to happen. Finally, I'll talk about the bias blind spot. This is based on work by Emily Cronin and her colleagues. She's an excellent psychologist. Psychologists have claimed, and she presents people with this statement. I have to say, if the shoe fits, psychologists have claimed that people show a self-serving tendency in the way they view their academic or job performance. This is called a self-serving bias, quite sensibly. That is, they tend to take credit for success but deny responsibility for failure. They see their successes as the result of personal qualities like drive or ability, but their failures as the result of external factors like unreasonable work requirements or inadequate instruction. I think I have some of them. And then she would ask people, are you like that? And they rank themselves on a 1 to 7 scale. What about the average American, or among college and graduate students? What about others in your situation? And people admit that they have this, but they always think that they have less of it than everybody else does. And they also think their parents have less of it incidentally. I don't know about their kids or their siblings, but they give their parents credit for making them less biased than the rest of the world. This is a dangerous thing to do. It's what you see when you see the people from the Goldman Sachs debacle reporting solely on the history of their states of mind, while everybody else thinks they were doing terrible things. That's an example of it. Well, I'm going to conclude with some observations. The first, to recapitulate, the test for legal writing faculty, with respect to at least these heuristics and biases, is to teach students that they should write simply and clearly because people will think they're smarter, to recognize the other side's arguments and counter them effectively, because there's a tendency to get sufficiently excited about one's own evidence as not to see how you can lose the case, only to see how you can win the case. That's the equivalent of not recognizing that you should turn over the 7 card. Deal with the fact that participants in the legal system, they pay excessive attention to character and inadequate attention to the facts, and you can either try to exploit that or counteract it depending upon what your litigation goals are. And finally, to admit that you are biased, and more biased than it may feel to you, sorry if that's a typo, and step back so that you may act disinterestedly. The hypothesis of this presentation is that when students are made aware of the psychological research that demonstrates the importance of these tasks, they will be more focused and conforming their writing accordingly. I can't prove that to be true, but that really is the overarching motivation behind introducing this kind of psychological research to legal writing students. And I think that there's really a great deal of merit to it. And I think you can see from this presentation that it really doesn't take very much. That is, introducing this kind of experimental work into the curriculum can be done relatively quickly and dramatically, and hopefully it will catch on for the students. So thank you very much.
Are there any questions of Professor Solon? We have microphones that the students have available.
Can you see me now?
Yes. Yes.
Okay.
Go ahead, Kathy.
Hi, Larry. It's Kathy Stanchi. Can you hear me?
Hi.
How are you?
Good. How are you?
Good. So I wanted to ask you about the first study about writing simply, because it appeared to me, and my guess is to a lot of the folks in the audience, that both of those paragraphs were rather complex and erudite, even if one was slightly simpler. And I wondered if there were any studies or there was any data about what happens if you truly, for example, if that paragraph had been translated as something along the lines of, I'm confused about God and I'm going to write about it now. Really simply, is there still the presumption that that person is smart, or does that disappear when it gets too simple?
I'm more than happy to send you a PDF of the study. Oppenheimer used a great 4 or 5 experiments, and they included such things, college essays, where some people write college essays, so it's in Caulfield, the Egyptians wrapped their dead in cloth so they would talk free. And then some, like, good college essays. So there were lots of examples that would resonate better with observations.
Your voice is breaking up there, Larry.
Sorry.
Speak a little closer, maybe, to the mic.
Okay, can you hear? Is this better? Yes. My apology. What I was saying was that Oppenheimer's 4 or 5 examples, I only gave you one of them, and I think some of them would resonate up, and I'm more than happy to send you the study and see whether you think that's the case.
Any other questions? All right, thank you so much. It was wonderful hearing your presentation, and we appreciate your getting up probably before dawn so that you could make it. Thank you.
So much for this was great.
Okay, what I would like to do now is proceed with our, didn't mean to cut him off.
Sorry.
Our first panel, and the first speaker is Dan Medway, a professor of law at Northeastern Law School, and as Dean Allard said, an alum of the faculty of Brooklyn Law School. He will speak on the egocentric bias in American criminal law.
Just minimize this.
Maybe I should just go on Skype to make it fun. Should we do that?
Thank you, Lloyd. Just 1 second. Oh, that's you. You don't actually. Great.
I don't have anything. Well, good morning. It's absolutely fabulous to be back at Brooklyn Law School. As Marilyn indicated, I'm an alum of the faculty. What she neglected to mention is I'm an alum of the legal writing faculty. Marilyn and Betsy gave me my start in law teaching. And even though I haven't taught legal writing in over a decade, I still firmly believe that it's the most important course in the 1L curriculum. We spend a lot of time talking about how we train our students to think like lawyers. Well, as far as I can tell, the legal writing class is the only one required course where we teach them to be lawyers, which nowadays I think is very, very important. So thank you, Marilyn and Betsy. Your book, Writing and Analysis in the Law, occupies a very prominent place on my bookshelf, and I consult it very often, all too often, especially in preparation for today. So in any event, I'll start off with a little bit of an anecdote. One of the most important lessons I learned when I graduated law school was the concept of managing expectations. One of my friends said to me, you're going into your first job, you're going to a law firm, and if they expect you to bat 100%, then you're bound to disappoint. If you hit 90%, they'll think you're bad. So just make them think that their expectations are 75%. So if you hit 90%, you'll exceed expectations and look good, even though that's the same amount that you would have hit if they had expected 100. In other words, success is entirely relative based on how the audience perceives you to be and what their expectations are. So that's a long way of giving you the following story. So I took this message to heart, probably too much. And one of my first assignments for a very intimidating, successful partner, it was a very difficult assignment. And after I had completed it, I went up to him and I said, Peter, just want to let you know that this may be a little bit simplistic. Bad choice of word. A little bit simplistic. Let me know if I can do anything else on it. He took the document, went into his hovel, his cave, for a couple hours, and then he came out, throwing the document in the air, knocked on my door. Actually, he just barged right in. Dan, you're right about one thing here. You're absolutely right about one thing. It is simplistic. And my question for you is, are you a simpleton, or did you simply not have enough time? So I'm giving you a talk that is relatively simplistic. It's relatively rough. I hope you don't construe me to be a simpleton. I promise that by the time the paper is due, it'll be more fully fleshed out. So what I'm going to talk about today, as Marilyn pointed out, I'm calling it the good fight, the egocentric bias in American criminal law. And I'd like to start off by talking about the idea that cognitive bias often, the term cognitive bias, often has negative connotations. It's something to be overcome or thwarted. My position, however, is that when channeled properly, certain cognitive biases can be tools in your tool chest that can help you to become an effective advocate both orally and in writing. Okay? So first of all, I'll start with a quote from Mark Twain. Mark Twain had a number of fabulous quotes. This is not one of them, but it suits my purposes. He once said, quote, that a man cannot be comfortable without his own approval. The very idea that comfort in your own skin is a very important self-defense mechanism as you go through life. It creates a cognitive force field that protects you from the slings and arrows, the indignities of everyday life. Some people would say this is a bad thing. It's delusion. Other people would say it's a good thing. It's a way to have a shell like a turtle that will make sure that you're protected and secure. So this is a concept that cognitive psychologists have explored. It's often called the egocentric bias. It relates a little bit to what Larry was talking about, the self-serving bias. And it has a couple different components. First of all, one component is it suggests that you perceive information in a way that enhances a positive self-image, that we all need on some level to construct a positive self-narrative, a positive narrative of ourselves. And we interpret information in a way that enhances that. It also means that we tend to overestimate our own importance in the world. For those of you who have children, you're well aware of the egocentric bias. And it means that you tend to overestimate the extent to which your values are shared by others in the world. I now live in Cambridge, Massachusetts, the most opinionated zip code in the world. And I confront this bias on a daily basis. Couple examples. The person who fails a law school exam may often attribute it to the harsh grading and unfair practices of the professor. The guy who is dumped by his girlfriend is misunderstood, not a poor catch. And for students in the room, this one might be the most apt. The professor who gets horrific teaching evaluations is too demanding and rigorous for the students, rather than a weak communicator. Those are examples of the egocentric bias, how you interpret information, Larry's self-serving bias point, and cast blame on external factors. Anything that's bad is attributable to an external factor. Anything that's good is attributable to your own innate intrinsic skill. Now, the egocentric bias is related to the concept, another concept. It's sort of a mirror image of the egocentric bias. It's called the aversion to cognitive dissonance. If you construct a very positive self-image, which we all do, then you clearly are averse to any information that would undermine that positive self-image, would create dissonance. If you have a positive view of yourself, and then there is hard data suggesting otherwise, you're a scoundrel, you've cheated on your spouse, you've done something horrible, then you tend to discount it or negate it, neglect it entirely. That's called the aversion to cognitive dissonance. So to go back to the example of the student who's failed the exam, the student who fails the exam and attributes it to harsh grading of the professor, that's the egocentric bias. That's the positive self-image at play. But that same student who neglects to account for the fact that he failed to prepare at all, that he was completely lazy, he never went to class, he was going to the Brooklyn Nets games all fall, that's the aversion to cognitive dissonance, the failure to come to terms with your own flaws because it would create dissonance, cognitive stress for you. Now, how does this relate to the theme for today? I've been trying to come up with that recently. In terms of criminal law, which is my area recently, my position is that the egocentric bias and the aversion to cognitive dissonance affects criminal law practice in both big picture ways and little picture ways. So let's talk a little bit about the big picture, and then we'll go into the little picture. In terms of big picture, we all have these narratives of ourselves. That narrative can be our personal narrative, good spouse, good father, good friend, or it can be your professional narrative, good lawyer, effective lawyer. For criminal law practitioners, because of the vivid, gory nature of this work, because the work is often not driven by monetary considerations, especially for prosecutors and public defenders, the professional narrative you construct to maintain a positive self-image and to make sure that you are averse to cognitive dissonance is often on the border of self-righteousness. For those of you who've seen criminal law practitioners in action, some of these images might resonate. The prosecutor who perceives of herself as an avenger of the victim, the protector of the public, the pursuer of evil, right? The public defender who views himself as the guardian of the Constitution, the protector of the little guy against the awesome, overzealous power of the state. These simplistic but important self-conceptions are the big picture in which cognitive bias can create that cognitive force field, that shell for the turtle that will protect the practitioner over the course of the criminal law practice, which can be very, very problematic. A corollary to this, of course, is demonizing the other side. The prosecutor is the avenger of the victim. The defense lawyer is the sleazebag protecting the evil defendant. The defense lawyer, guardian of the little guy, will view the prosecutor as essentially a rogue state aggressor. I was shocked when I was a public defender and I see my beloved first supervisor in the audience, Kevin Casey from 1998. I was shocked by the amount of World War II imagery in the office. Colleagues who would come in and say, "Those Nazis are coming after my client." It was like the resistance on Rector Place, you know. And this idea of the public defender as the resistance against the Gestapo, against the Nazis, the prosecutor, was really alarming to me and a little bit disturbing. Now, once this bleeds into self-righteousness, that's a problem, because self-righteousness, of course, is consistent with delusion. And if you're delusional, you may not be an effective advocate. But if you can keep the egocentric bias and the aversion to cognitive dissonance on the correct side of self-righteousness, that is, the side of confidence, of self-belief, of being a formidable and a convincing advocate, then it can be an effective weapon. So let's now look at the little picture moments where cognitive biases, these cognitive biases, can be helpful. 5 moments, many of which were informed by my experience working with Betsy and Marilyn. The first is framing the theory of the case. When you get a case as a prosecutor, you get the arrest file, or your supervisor hands it to you, or if you get it as a defense lawyer, you initially have to come up with a theory, with a vision of the case. This theory is not necessarily something that you commit to paper, but it's something that is part of your own approach to the case. It's central to your case. In fact, I should amend my statement. I would develop my theory of the case and I'd put it on a little yellow sticky and put it on my desk. Remember, this is what the case is about. And oftentimes it could be boiled down into a very specific mantra. So an example from one of my old cases, client will be nameless, classic late 90s case. A man is in a high crime neighborhood of New York, walking allegedly briskly and casting furtive glances, this is the language from the police, when an undercover police officer, a member of the infamous street crimes unit, which Rudy Giuliani had created, goes and approaches this person, believing that he has reasonable suspicion to stop and frisk this person. The person resists, at which point the police officer throws the guy to the ground and conducts a rather invasive search. He feels something, he calls it hard, in the defendant's waistband that he claims felt like a weapon. He retrieves it. It turns out to be a brick of cocaine, right? A hard object, but certainly not commensurate with being a weapon. So from my view as a former public defender, this case, my theory of this case, is rather simple. Overzealous street crimes unit, my colleagues would say, you know, SS warrior, takes out citizen, invades citizens' privacy, who's simply walking briskly down the street like any New Yorker does. Having come to New York after a few months away, I notice how everyone walks briskly and casts furtive glances behind them. This is New Yorkers' paranoia plus traffic plus overcaffeination, you know, the fusion of being in Gotham, right? So that's clear. That's my theory. Overzealous police, overreaching, literally overreaching by this police officer. Prosecutor's vision is entirely different, same facts, but the egocentric bias, aversion to cognitive dissonance, could inform a very different theory. Noble police officer, threatened potentially by a man in a high-crime neighborhood, takes out a major drug slinger, right? Not overzealous police officer, but dangerous criminal caught by noble police officer. The egocentric bias, your vision of the world, prosecutor as avenger of victims, protector of the little guy, will infuse that theory of the case and help you throughout the process. Next little moment that's important, selling the case internally. If you're a prosecutor or you're working for a public defender's office, the first thing you have to do is pitch your case to other members of the office, especially if you're a prosecutor and there's some type of charging review committee. You're entrusted with this case, you're looking at the file, and you're figuring out how to charge it. How do you sell this to your office? How do you sell it to your supervisors? Here's a little anecdote from California. Famous case from the 1980s in Santa Clara County. A man had a fighting dog. Willie was the name of the dog, who had done lots of dog fights, illegal dog fighting, a pit bull, rabid, killed dogs right and left, very dangerous animal. He was so dangerous that the owner had him affixed to a stake. But the stake wasn't enough with a chain. It was actually tied to an axle, a car axle, that had been embedded in the ground with cement. This was a dog that needed to be restrained. Unfortunately, this man lived next to a young couple that had a 4-year-old kid. And the 4-year-old kid wandered too close to the dog and was killed by the dog. Okay? There was an element of negligence or recklessness, of course, on the part of the dog owner. You shouldn't have fighting dogs. It's illegal, right? And maybe there would have been a better way of restraining this particular dog. So prosecutors get this case in the homicide unit. 5 of them are sitting around in a room. And there's a guy next door who's not even in the homicide unit. And he's hearing about this case. And he walks in, he grabs the file, and he said, "You give me this case, I'll make it a murder." This isn't negligence. This isn't regular manslaughter. This is extreme indifference to human life murder. We shouldn't tolerate rabid fighting dogs in our community taking out kids. He got the case. He ran with it. He became a rather prominent prosecutor in Santa Clara. He sold the case. The case wasn't about an unfortunate accident, which is how a defender might view this, an unfortunate accident. There was also some evidence that the defendant hadn't been fighting the dog recently, was trying to sort of rehabilitate himself, and didn't know what to do with the dog. Contradictory evidence on that count. But an example of selling the case internally, this man wasn't even part of the homicide unit. But he took it, and because of this bias, this sense that he was the protector of the public, that he was the avenger of the victim, give me the file, I'll make it a homicide. A very successful use of that particular bias. Third little moment. There are only 5 of them, so I'm almost done. Third moment. 95% plus of cases plead out. Some folks say that we don't live in a world of adjudication. We live in a world of prosecutorial adjudication. Prosecutors charge and sentence by the very nature of their plea offers. It's how it works. Very few cases go to trial. The only cases that go to trial are the close calls where the defendant may be innocent, where the bizarre delusional cases where the defendant is delusional and doesn't want to take the plea, or the cases where the prosecutor is delusional and doesn't offer a plea. Very few cases. So the vast majority of criminal law cases are adjudicated in the hallways, in the bathrooms, right, in very harried negotiations. So how does the egocentric bias work? A lot of scholars talk about how plea bargains occur under the shadow of the trial. There's this rich literature about how prosecutors and defense lawyers have this sense of assessing the likelihood for success at trial, and then they tailor their plea bargaining strategies to reflect their assessment of the likelihood of success. I think that's crap. I don't think that works at all. I think what happens, based on my experience and having talked to people, right, totally qualitative and not quantitative, is that it's your construction of the narrative that dictates the force with which you present your plea offer and your ability to accept or reject it. So the reason why people plead out, of course, as defendants, is it's something called the trial tax. If you go to trial and you're convicted of the same charge that you were offered during the plea bargain, you're going to be sentenced at a higher rate. Whatever the difference is between your plea offer and your trial sentence is considered by defendants to be a tax. It's a trial tax, a tax on your assertion to go before a jury. Prosecutors do this quite differently. It's not a tax, it's a plea discount. You're given a discount to accept the plea bargain. Again, egocentric bias. I'm giving you a deal, says the prosecutor, if you accept now. Defense lawyers, no, you're taxing me. You're taxing my constitutional right to go to trial. So that conception of, I'm a good person, says the prosecutor, I'm giving you a discount, is very, very helpful in those negotiations. Whereas for the defense lawyer, it's not a discount, it's a tax. You're taxing my right to protect the individual. It can also be very, very powerful. Fourth moment, of course, is at trial. And most lawyers, most of us, of course, are susceptible to another bias known as loss aversion. And the idea is that if we frame certain moments as wins and certain moments as losses, we'll basically devote all of our attention to maximizing the wins and minimizing the losses. So that's one of the reasons why plea bargaining is also very successful. A prosecutor will view a plea as a win, it's a conviction, without the uncertainty of going to trial. And a defense lawyer can also, we've seen this in public defenders' offices, treat certain plea bargains as wins as well. I got a good deal for my client. That's a win. He was facing 25, I got 15. So loss aversion affirms that, or reinforces that. At trial, though, it is win or lose for the lawyer. It is absolutely win or lose. You get a conviction. It shouldn't be, but that's how it's perceived. So the way that the egocentric bias and the aversion to cognitive dissonance can work here is simply on presenting your narrative to the jury. A lot of the literature on jury decision-making suggests what? Jurors completely disregard the instructions. They render decisions based on one fundamental fact, their sense of the morality of the case. Is the defendant morally culpable? Is the prosecutor morally correct in bringing charges? In criminal law, even more so than in civil cases, this idea of a morality play, not a trial, is at its core. And obviously, this is where your construction of the case, the way that you transmit your theory, ideally in simple and direct terms, can be incredibly powerful. And then the last moment, before I conclude, is of course the moment that Professors Fajan and Walter focus on a lot in their book, and Professor Bentley as well in her appellate advocacy text, which is how do you write an appeal in a way that's persuasive and effective? Of course, your theory of the case should infuse your appeal. You present everything in a powerful and persuasive way, but again, with your image of the case overlying the entirety of the presentation. I won't spend much time on this because people who are more expert on this will be able to elaborate on it. But those 5 moments, in my view, right, your framing of the theory of the case, your selling of the case internally within your office, your plea bargaining posture, your presentation to a judge and jury, and your writing on appeal, these are situations, in my view, where the egocentric bias and the aversion to cognitive dissonance can be advantages. They can be tools in your tool chest as long as you don't bleed into self-righteousness. Thank you so much. I will now turn it over.
I'm going to ask the questions for this panel at the end when all 3 speakers have gotten a chance to talk. And so I would next like to call on Michael Smith from the University of Wyoming Law School. And he is going to talk about the role of cognitive bias in policy decision-making.
Good morning. My presentation today is actually part of a larger project I chose to speak about the part that actually is relevant to cognitive bias, I think, which makes sense. There's actually three aspects of my presentation, not my presentation, of the article that I'm writing. And my article explores the nature of policy-based persuasion in terms of sociology theory and cognitive theory. And you can see that there's actually three aspects to my project: the nature of policy arguments in terms of those two disciplines, sociology and cognitive theory, types of policy arguments in terms of those theories, and then the last, strategies for maximizing the persuasive impact of policy arguments in legal advocacy. And it's this third aspect that I'm going to talk about today. And I'm not going to be able to go into all of that part even of itself, but I will give you a taste of it and try to focus primarily on the cognitive bias components. So the first thing we should do is start with a definition of policy arguments in the context of legal advocacy. And so the definition that we're going to be working with is a policy argument is an argument made by a legal advocate to a court that urges the court to resolve the issue before it by establishing a new rule that advances or protects a particular social value implicated by the issue. And there's actually two important parts to this definition. The advocate is asking the court to establish a new rule, and secondly, that rule is designed to advance or protect a particular social value. So the best way to understand this definition is to, sorry, I keep doing that. The best way to understand this definition is to look at an example of a policy argument that will play through the rest of the presentation. The issue before us is whether interspousal immunity should apply to a tort suit, to a tort suit between divorced spouses for a tort committed during marriage. Some states have interspousal immunity that prevents one spouse from suing another for a tort committed during marriage. And the original reasons for the interspousal immunity is twofold. First, jurisdictions that establish interspousal immunity recognize that a lawsuit by itself, in and of itself, is adversarial, and that allowing one spouse to sue another will have an embittering effect on the marriage when spouses are on the opposite side of a lawsuit. The second reason why interspousal immunity is recognized in some jurisdictions is to avoid collusion against insurance companies. Because spouses share the same purse, a judgment against one on behalf of the other, if an insurance company is paying for the judgment, will actually benefit both spouses. And so the thought is the defendant spouse wouldn't do all in his or her power to defend the lawsuit, knowing if they lose, they actually benefit from a financial windfall. And so the question before us is, should interspousal immunity apply to a suit when the tort happened during marriage, but the suit happens after divorce? Obviously, the plaintiff is going to argue, no, it shouldn't. There's no longer marital harmony to preserve because the parties are divorced. And secondly, if there is collusion going on, it's no more automatic collusion because the parties no longer share the same purse. And so there's no more likelihood of collusion than there would be between any other two individuals suing each other. So the plaintiff would argue that interspousal immunity should not apply to that situation. The defense, however, has a policy argument. The defense could argue that if interspousal immunity does not bar a lawsuit between divorced spouses for a tort that was committed during marriage, it'll actually encourage divorce on a societal scale. Because if there is a tort that occurs during marriage, the plaintiff's spouse will have to decide whether to stay married and not be able to recover for their injuries or get divorced and be able to recover. And some spouses will choose the latter. Will choose, I want to recover. The only way to recover is to divorce, and therefore interspousal immunity will not apply, and therefore I'll be able to sue. So the policy argument is that not barring a suit in this scenario will actually encourage divorce as a means of getting around interspousal immunity. It will encourage divorce on a societal scale. Now, in terms of our definition of a policy argument, what the defendant would be arguing is the court should establish a rule that interspousal immunity applies even after divorce for a tort committed during marriage in order to protect marriage as an institution and to avoid divorces. So you see how that fits our definition of establishing a rule that advances or protects a particular social value. And we'll turn back to this example several times when we go through the various components of a policy argument. As I said, my presentation today is focusing on the third aspect of my article, which is strategies for maximizing the persuasive impact of a policy argument. From a cognitive standpoint, a persuasive policy argument has three components. There's the probability component, there's the importance component, and there's the memorability component. And cognitive bias actually plays a role in all of three of these, as we will see. The first component of a persuasive policy argument is probability. What is the probability that the consequences implicated by the policy argument will actually occur? So in the context of our interspousal immunity example is, what is the probability that if interspousal immunity does not apply to divorced spouses for a tort committed during marriage, what is the probability that that will actually encourage divorce? And so the first aspect of any policy argument is, what is the probability of this threat that is being threatened, or if the policy argument is encouraging good behavior, what's the probability that the good behavior will actually be encouraged? The question is whether the probability is likely or far-fetched. The second aspect of persuasive policy argument is the importance component. How important is the value implicated by the policy argument in and of itself, as well as in relation to the competing policy arguments implicated by the opposing side? In the example of the interspousal immunity example, the question is, how is important to the decision maker, picture a judge, how important is avoiding divorce? Is that an important value, or is that not so important? Well, I really don't believe in the institution of marriage, so it's not really a big deal to me. How important is that as a value to the decision maker? That's in and of itself. But you also have to take into account how important is that value in relation to the competing value. The plaintiff also has a policy argument. Access to the court, the right to be compensated for injury. I mean, that's why we have a court system. And so the second aspect of a persuasive policy argument is how important in the hierarchy of values of the decision maker is the implicated value by your argument in and of itself, or in relation to the competing value. The third component of a persuasive policy argument is memorability. How memorable is the policy argument to the reader or the audience, or just does it get lost in the morass of arguments that are being given to the judge, or does it stand out? So as I said, cognitive theory, as well as the more narrow theory of cognitive bias, applies to all three of these. So let's talk first about probability strategies. This aspect of my article will focus on strategies that a legal advocate can use to increase the perception of the probability of the consequences that are being alleged. The article I'm writing is going to talk about strategies for increasing the perception of probability that are not related to cognitive bias, as well as those that are related to cognitive bias. So let me give you an example of one first that is not related to cognitive bias. So again, the article will discuss many, but I'm only going to talk about one here. One way that you can increase the probability or the perception of probability of the consequences is by using legislative facts to prove the likelihood of the alleged future implications. Ellie Margolis, Kathy Stanchi's colleague at Temple, has written an article that discusses how attorneys can cite non-legal sources to prove facts or to prove assertions, such as scientific studies, medical reports, social psychology articles, history papers, legitimate, credible, non-legal sources to prove facts that are alleged, particularly in the context of policy argument. In the context of our interspousal immunity hypothetical, then, if the first thing we're trying to do is prove the perception of the probability that divorce will be encouraged, if interspousal immunity doesn't apply to a tort lawsuit between spouses that are divorced for a tort that was committed during marriage, it is possible for an advocate to increase the perception of that probability of encouraging divorce by citing articles that show that one of the number one reasons that spouses divorce is for financial reasons. There's a lot of literature out there that explains that if not the number one reason for divorcing, one of the top reasons for divorcing is based on finances. And so with that knowledge, the probability that someone would divorce in order to have the opportunity to recover for a tort suit is heightened. It increases the probability that someone would actually end their marriage for the financial reason of being able to recover and get around interspousal immunity. The second example is from a real-life example from United States versus Smith. United States versus Smith is a Supreme Court opinion with a very interesting issue. In that case, there was a statute, federal statute, that makes it a crime to use a firearm during or in relation to a drug trafficking offense, using a firearm. The defendant in that case went to a drug deal and said, I want drugs, and in exchange for drugs, I'll give you my gun. And so the defendant was actually convicted under the statute for using his gun in relation to a drug trafficking offense. He used it for barter. Probably not what the legislature had in mind when they crafted the statute. They were thinking about using a weapon or a firearm as a weapon, but that's exactly the issue that the Supreme Court addressed. What does the definition of use mean? Does it mean using as a weapon, or does it mean, could it include using as an item of barter? The Supreme Court, with the majority opinion written by Justice O'Connor, held that the word use does include using for barter. And so the defendant had an enhanced sentence of 20 years because instead of using cash, he used a gun for his drugs. Part of the policy argument that Justice O'Connor in the majority opinion argues is that the word use should be interpreted very broadly to send the message to society, specifically the drug-using society, to leave your gun at home when you go to a drug deal. We want to interpret the word use as broadly as possible so it sends the message, guns and drugs are a dangerous combination, leave your gun at home. And so the policy argument was the word use should be interpreted as broadly as possible so it will lead to safer situations and avoid the danger situations of having a gun at a drug deal, because a gun can quickly be converted as an item of barter into a weapon at the drug deal. So leave the gun at home. Now, as part of this policy argument, Justice O'Connor actually cites some non-legal sources to support the probability. What is her argument, the policy argument, is based on the probability that having a gun at the drug deal, even if it's there as an item of barter, can be dangerous. And so to increase the perception, the probability of that danger, Justice O'Connor cites some non-legal sources. You can see this in the United States versus Smith case. When Congress enacted the current version of 924C1, it was no doubt aware that drugs and guns are a dangerous combination. In 1989, 56% of all murders in New York City were drug-related. During the same period, the figure for the nation's capital was as high as 80%, and there's a cite to authority. So this is an example of a persuasive strategy in the United States versus a Smith opinion, where Justice O'Connor wanted to increase the perception of the probability of the danger aspect upon which her policy argument relied. And so she cited authority showing that guns and drugs are a dangerous combination. So my policy argument that we should send the message that drug dealers should leave, or people engaged in drug dealing should leave their guns at home, is increased, the probability of the perception of that danger. So that's an example of a strategy for improving the perception of probability of the consequences that's not related to cognitive bias. But that's not why we're here. We're here to talk about cognitive bias. So the next thing is to talk about a strategy for improving the perception of probability through strategies of cognitive bias. And again, there are several, but I'm only going to talk about one today. And one of those is this idea of combining a less likely or more extreme consequence with a more likely or less extreme consequence. This is called the conjunction fallacy, which is a cognitive bias. Under the conjunction fallacy, people tend to believe that a less probable condition or event is more likely if it's combined with a more probable condition or event. And I know you're trying to have a hard time getting your mind around that without an example. So let's talk about a fairly famous study that talks about conjunction fallacy by Amos Tversky and Daniel Kahneman. This is a very famous study. Subjects of this experiment were given this paragraph. It says Linda is 31 years old, single, outspoken, and very bright. She majored in philosophy. As a student, she was deeply concerned with issues of discrimination and social justice, and also participated in anti-nuclear demonstrations. The subjects were then asked this question: which is more probable? That Linda is a bank teller, or Linda is a bank teller and is active in the feminist movement? Now, from a mathematical standpoint, number one is more probable, because both the probability of two things occurring is always mathematically less than one thing occurring. And so mathematically, number 1 is the answer. 90% of the subject shows number 2. 90% of the subject shows number 2 because one of those seemed very likely. And that is that she is active in the feminist movement based on the paragraph. And so the subject said, well, if that one's likely, the other one seems even more likely too. And so this study has been repeated over and over again, that if you combine a less likely consequence or event with a more likely consequence, the perception that the less likely consequence will happen seems more likely. And so this also can be applied in a policy argument to try to improve the perception of probability of the consequences implicated by the policy argument. We can see an example of that in Justice Ginsburg's dissent in Illinois versus Caballes. In that case, the defendant was pulled over in his car for speeding. There was no other suspicion of drug activity, just pulled over for speeding. While one officer got the license and registration from the defendant for speeding, another officer pulled a canine dog out of the back seat of the car and just circled the car without any suspicion of any activity. The dog detected drugs. They opened the trunk. Sure enough, there were drugs, and he was convicted of possession of drugs, even though there was no suspicion of any activity other than speeding. And so the issue in the case was that a constitutional search? Because there was no probable cause, there was no suspicion of any activity. And the issue came down to, do we have an expectation of privacy for the outside of our car? If a dog is walking around our car, do you expect that a dog will not smell drugs if you have drugs in your car? This is a very controversial case. Justice Ginsburg argued a policy argument that this should be the evidence received as a result of that search should be excluded from the trial because of privacy rights. That this was an illegal search, and she argued that there are privacy rights implicated here, and that the rule should be that you can't have a canine dog sniff a car without some kind of suspicion or probable cause, and that violates our expectations of privacy. So Justice Ginsburg, going back to our original definition of a policy argument, the rule should be that dogs can't do that, police can't do that, and the reason for that is to protect rights of privacy. And so that was going back to our original definition of a policy argument. You can see that she wasn't successful. I know it's ironic up there that it's a dissent, and I'm trying to talk to you how to be persuasive, and so that is somewhat ironic. And that's why a lot of the examples I'm writing about in my article do not involve constitutional questions, because people are very polarized on constitutional questions, and even cognitive bias can't move you off your position in the context of most constitutional questions. But this does serve as a good example. In Justice Ginsburg's dissent, she employs this conjunction fallacy by talking about the consequences of the court's decision. She says, today's decision clears the way for suspicionless dog-accompanied drug sweeps of parked cars along sidewalks and in parking lots, nor would motorists have constitutional grounds for complaint should police with dogs stationed at long traffic lights circle cars waiting for the red signal to turn green. Now, the implication that police can now do that, circle cars without a warrant or without probable cause, probably will happen in parking lots. That is a likely consequence. It happening at a traffic light is probably a little bit extreme, that while you're waiting for light to turn green, there are police going around your car at the traffic light trying to search for drugs. But Justice Ginsburg made the appearance of that second consequence perceived to be more probable by combining it with the more probable event of searching parked cars in parking lots and along the street. So this is a classic example of the implementation of the conjunction fallacy cognitive bias strategy of combining a less likely or more extreme consequence with a more likely or less extreme consequence to make both of them seem more probable. Again, we're talking about the three components of a persuasive policy argument, and the second is the importance. How important is the value implicated by the policy argument in and of itself and in relation to the competing policy argument. My article talks about ways to increase the perception of importance, both in terms of non-cognitive bias strategies as well as cognitive bias strategies, and I discussed several, but I'll talk first about an example of a strategy that does not involve cognitive bias, and this again relies on Ellie Margolis' article. Not only, you remember we talked about you can cite non-legal materials for increased perception of the probability of the consequences. You can also cite non-legal materials for improving the perception of the importance of the consequences. Going back to our interspousal immunity example, we talked about how we could cite sources that show that couples often divorce for the purposes of finances to increase the perception that allowing people to sue and get around interspousal immunity for a tort committed during marriage, if they divorce, will encourage divorce. Well, the next question is the importance. Well, how important is divorce? Why should avoiding divorce be important to me? Why should the institution of marriage be protectable or be worthy of protection? Well, you could also, as an advocate, cite non-legal sources that show the negative consequences of divorce. The negative consequences of divorce on the individuals, on the children, and on society as general. And so you can cite non-legal sources to say, well, even if you, judge, don't think this is important, let me show you the impact of divorce on society and on the individuals that are involved in the divorce. So that's another non-cognitive bias strategy for improving the perception of the importance of the consequences. What about a strategy based on cognitive bias? If possible, state a policy argument in terms of avoiding a loss rather than in terms of acquiring a gain. Both things are positive to an individual. If you avoid a loss, that's great. If you acquire a gain, great, that's great. So both are good. But studies show that people are more motivated by avoiding a loss rather than acquiring a gain. There's two cognitive biases that underlie this. One is the endowment effect. People are more motivated to avoid a loss than to acquire a gain, and studies show that over and over again that is true, that people are more motivated to avoid losing something they are to acquire something. The second cognitive bias underlying this is the negative bias. People pay more attention and give more weight to negative information than to positive information. So how would this strategy apply in the interspousal immunity example? In explaining the potential consequences for not applying interspousal immunity to a tort lawsuit for a tort committed during marriage but the parties are divorced, this strategy would suggest that you should argue in terms of avoiding divorce rather than preserving marriage. That the explanation should be in terms of avoiding the negative rather than acquiring the positive. And so the strategy should be explaining the argument in terms of avoiding the encouragement of divorce as opposed to preserving marriage as an institution. We see another example of this in the United States versus Smith case. Remember, that was the case where the United States Supreme Court interpreted the word use of a firearm to include using a firearm as a weapon, as an item of barter. Justice O'Connor, in her opinion, also employs this strategy very well in accentuating the avoiding of a loss as opposed to acquiring a gain. Nowhere in her opinion does the word safe or safer appear. Nowhere does she say society will be safer if we interpret the word use broadly and send the message that people engaged in a drug deal should leave their gun at home. There are numerous references to avoiding danger. In the opinion, Justice O'Connor has many references to how this decision will avoid and avert dangerous situations of defendants taking their guns to a drug deal. The last aspect is the memorability aspect. And there are strategies for increasing the memorability of the policy argument, and my article discusses many, but I do want you to know about the von Restorff effect. We've grown up knowing that If you want someone to remember something, accentuate it, highlight it, make it stand out. Well, there's actually cognitive studies that show that. And so in our briefs, when we do separate sections and we have headings, all that is a manifestation of the Van Restorff effect, that we're actually trying to make it stand out so the reader will remember it. There are many ways to employ the Van Restorff effect and to increase the memorability, but one strategy is to use rhetorical figures of speech, including literary allusion, metaphor, alliteration, antithesis, metonymy, and many, many others. I'll just leave you with one example from Justice O'Connor's opinion in the Smith case regarding the broad interpretation of use. In arguing that we should send the message that the people should leave their guns at home and that the word use should be interpreted broadly to avoid the dangerous situation of guns at drug deals, she employed a very memorable, very juicy, very quotable quote example of alliteration. She wrote, "The fact that a gun is treated momentarily as an item of commerce does not render it inert or deprive it of destructive capacity. Rather, as experience demonstrates, it can be converted instantaneously from currency to cannon." And that was not a mistake. She included that very artful use of alliteration to make that whole argument very memorable. And she is employing the Van Restorff effect by using alliteration to make that argument stand out. There's a lot more on all of these, but I want to stay within my timeline, so thank you very much.
Thank you, Michael. The final speaker of this panel is Kathy Stanchi, a professor at Temple Law School, and she will discuss the scientific support for cloaking your advocacy in reasonableness.
I'm sort of tempted to tell you before I start that I'm rich so that you think I'm smart. But since I'm an academic, you probably wouldn't believe me, so that wouldn't work so well. So let's see if I can, great. So what I wanted to talk to you about today is something that I've been thinking about for a while, and I've only really am at the beginning of studying it. But that came up in teaching legal writing to my spring semester students, which is when I teach advocacy. And students always ask me, you know, how hard should I push? What should my tone be? They're making the transition between counselor and advocate, and they think I have a golden rule to tell them about, you know, how aggressive or zealous to be in their advocacy. And of course, as you all know, that I do not. But I did think that maybe there was a way to study whether psychology could tell us some things about what happens in an audience or decision maker's mind when we either hold back a little bit in our aggressiveness or when we push very hard. So in doing so, one of the psychological processes that popped up over and over again was cognitive dissonance, and I know Professor Medwed talked a little bit about this, but I'm going to really have this as a theme throughout my whole talk, so I thought we should talk about exactly what the definition is. This is a somewhat simple definition, but basically what happens in cognitive dissonance is when you have a strongly held belief and it clashes with either another strongly held belief that you have, or it clashes with some experience that you're having in reality. So if you like to think of yourself as a charitable person or a giving person, and a homeless person asks you for money and you don't give them money, that's going to cause you some amount of cognitive dissonance. If a member of MAD, Mothers Against Drunk Driving, finds herself tipsy and with only one way to get home, and that is to drive, and her children are waiting for her, that's going to cause her cognitive dissonance. It's basically an uncomfortable state that we seek to resolve as human beings. It's psychologically uncomfortable for us, and we will be highly motivated to change it. So what does cognitive dissonance teach us about how aggressive to be in our advocacy? Well, there's two things that I wanted to talk about today. It could probably tell us more than two, but I only have time for two today. And one thing that it does tell us is that it is important to avoid presenting either a story or an argument that seems too good to be true. And that is that on the flip side, it's important to acknowledge flaws either in our client's story or in our legal argument. Now, when I give this presentation to lawyers, I'm always worried that they're going to throw stuff at me. A lot of lawyers don't like to do this, and they're firmly in the camp of, you know, I'm supposed to be a zealous advocate for my client. I'm not the person who's supposed to discover bad things about my client. That's the other side's job. I'm not supposed to discover bad law about my case. That's the other side's job. So I understand that. This isn't certainly meant to say this is what you should do in every single instance. I'm just saying, here's what's going to happen in your decision maker's brain if you present to her either a story about your client that's too good to be true or a legal argument that acknowledges only the positive support in your favor and brooks no possibility that there's a viewpoint on the other side. So what cognitive dissonance tells us, and we'll go into a little bit of detail about that in a sec, is that that's something you want to avoid, that too good to be true, and we'll talk about why that is. Secondly, if you have a controversial premise that you ultimately have to argue to your decision maker, and by controversial I mean possibly you're arguing to overturn binding authority, or you're arguing against authority in some manner, or you don't have authority for your proposition, or the proposition is going to make the decision maker uncomfortable in some other way, there is a way to avoid cognitive dissonance, or at least minimize it so that controversial premise doesn't give the decision maker that uncomfortable feeling. So hopefully we'll be able to get to that. That's the second point. Okay, so arguments that are too good to be true. So this can take many forms, but the two most common are presenting a client's story as too good to be true, presenting the client as sort of the white hat, white horse. This is also a lot of what Professor Medwood was talking about. You get too involved in the good of what you're trying to do on your side, and it's hard for you to see the flaws in your story or your theory of the case. I just recently had an issue with this with one of my students. I gave them the exercise of saying, what image do you want in the judge's head when you describe your client? What's the picture you want them to have? If there's a celebrity you would want to have play your client, who would that be? And one of my students said, Mother Teresa. And I said, that's exactly not the right thing you want them to see. And here's why. The strongly held belief that almost everybody, all human beings have, is that nobody is perfect, and most arguments have two sides. So if you present your decision maker with something that appears to be too good to be true, you are going to arouse in them this uncomfortable state of cognitive dissonance. And they are going to strive pretty strongly to resolve that cognitive dissonance. Now, the interesting thing about cognitive dissonance and this strive to resolve it is that we almost never resolve it by changing our strongly held belief. Those we cling to, even if they're clashing with reality that's sort of hitting us in the face like a wall. We will seek to fiddle around with reality a little bit in preference to changing our strongly held beliefs. So, what are some common reactions to the cognitive dissonance that's aroused by a story or legal argument that seems too good to be true? Well, there's a couple. One is called reactance. That's kind of a fancy word, but I like to call that throw the baby out with the bathwater reaction. Reactance, like many of the responses we're going to be talking about today, is an emotional reaction. It stems from anger. The cognitive dissonance that the decision maker will feel based on this too good to be true story will clash with his belief that all arguments have two sides. So he will focus on changing the reality, and he will think that reality must be wrong because my belief is right, so there must be something wrong with the reality. When he gets to that point and says, gee, there must be something wrong with the reality, there is a likelihood that he will make the next step and say, this advocate is purposefully withholding something from me and trying to make me make a wrong decision. That's when the decision maker will get angry and have potentially this reactance response, which will mean the whole argument, baby out with the bathwater, pretty much everything you say from that point on of that resolution to the cognitive dissonance is going to be rejected by the decision maker, not by any stretch of the imagination something that you want to have happen in your advocacy. The other possible reaction that someone can have to the too good to be true cognitive dissonance is called overcorrection. And this is a cognitive bias, much like reactance. What the person will do is say, gee, this seems too good to be true. I'm going to hunt for a flaw. I'm going to be on the lookout for a flaw. And remember, I'm positing a scenario where you've maybe had your opening brief or your opening argument. We haven't heard from the other side yet. This is just what's going on in the judge's brain as he hears your too good to be true argument. So then he will think, gee, this looks too good to be true. I don't want to make a biased decision, and I want to be fair, so I'm going to put my thumb on the scale. I'm going to look for a flaw. I'm going to hunt around. Even if I can't find it, I'm going to put my thumb on the scale for the other side so that I try to make what I think to be a fair assessment of this case. The problem is that once you get the judge in that position where he's putting his thumb on the scale, most people are not able to make a fair decision when they're in the throes of that overcorrection bias. They will almost always bias on the other side. So essentially what you are doing by giving the judge a too good to be true story or legal argument is pushing him toward acceptance of the other side's argument, even before they've made their argument. So that's one thing that cognitive dissonance tells us about how hard to push. Sometimes we will get a really bad reaction if we push too hard and try to present our stories or our legal arguments as too good. Now, what happens when the flaw comes out? If we're in the throes of this cognitive dissonance and reaction or possibly overcorrection and a flaw does pop up, that is to say it's raised by the other side, remember now your decision maker is in this mode where they're looking for flaws because this seems too good to be true. Their world doesn't seem right. That's sort of part of the feeling of cognitive dissonance is my world is out of balance because this doesn't seem right. It doesn't feel right to me. And then a flaw comes. So I couldn't help myself. This is sort of your classic too good to be true story. And when the flaw comes, you get an utter degree of delight and schadenfreude because now the judge's world is all right. It's like, of course that couldn't have been, that was way too good to be true. I don't know about you, but a lot of people I know, we do this a lot with celebrities, with well-known personalities. We build them up, and then it seems like their lives are too good to be true, and then when the fall comes, it just feels right, doesn't it? And also, I love my adopted city. Philadelphia is my new city, but boy, do I miss the Post. Nothing like it in Philadelphia. So that's the one side, the presenting the too perfect argument, the too good to be true. On the other side, what cognitive dissonance tells us is that we actually get something positive out of fessing up, out of acknowledging our flaws in an argument or in a story, disclosing something about our client that makes him seem like somewhat less than Mother Teresa. So how does this happen? How does the cognitive dissonance work here? Well, what happens is that if the decision maker sees the lawyer as a biased source, now the catch here is we don't actually know how decision makers see lawyers, and there's two sets of studies in this arena. One that focuses on advertisers and marketers who are seen as biased sources, and others that focus on more kind of expert, making policy judgments or public service type information announcements, things like that, who are not necessarily seen as biased sources. We don't know where lawyers fall yet. There hasn't been research about that, and certainly it's something that I think needs to be done. But we don't know yet. My guess is it may fall somewhere in the middle because we are an expert source. We're probably also seen as biased by a lot of people. It also may depend on the decision maker, whether the decision maker is a judge or a jury. If we listen to what judges tell us, they certainly do expect us to disclose everything relevant about the case, including the flaws or the bad authority on the other side. Jurors may have a slightly different viewpoint on that, but in any event, assuming for the moment, before we get back to that people may see lawyers as biased sources, most people will not expect a biased source to disclose a flaw, either in the client's story or in an argument that we're making. So they will experience cognitive dissonance when we do so. The catch here is that the cognitive dissonance that people experience in this scenario, where a biased source discloses a flaw, as opposed to the cognitive dissonance they experience in response to a too good to be true argument, is they will resolve it by doing something called change of meaning. And this is something actually that there's been one study in the legal realm about this. What change of meaning refers to, it's the psychological shorthand catchphrase for a decision maker who takes a voluntarily disclosed flaw from a biased source and actually changes it to be not that damaging. So here you have this strongly held belief that a biased source will not disclose a flaw. That's the strongly held belief. It's clashing with the reality that you're getting a persuasive message in which a flaw appears to be disclosed. So again, what does the person do? They're going to futz with reality. They're not going to mess around with their strongly held belief. So they think to themselves, this flaw can't be that bad because it's being disclosed by a biased source. In the study was conducted by Australian researchers, so we have to be careful about generalizing too much to the American court system, but it's the only thing we have, so I will share it with you. It involved a simulated trial of a car accident. Graduate students read transcripts of a trial in which a defendant was charged with vehicular homicide. The other driver in the accident was killed, and the defendant disclosed a wide variety of bad pieces of evidence across the different studies. He was drinking prior to the accident. There's evidence that he was speeding. There's forensic evidence that he veered into the other side of the road. Across the board, if the defendant himself disclosed that evidence, even if he then attempted some explanation of it or resolved it or rebutted it in some way, what the graduate students who read those transcripts did with that evidence was either change it to be less bad. They literally remembered the evidence as different than what it was in the written transcripts. They remembered it but thought it was irrelevant, had sort of cast it aside and said it didn't make a difference to my decision, or they quite simply did not remember it at all. They could not remember that there was something bad that the defendant had done, because that's how strong our need is to resolve that dissonance. We will change reality. You know, it wasn't everybody who did that, but certainly some of the mock jurors changed the reality in that way. So there's a couple of things I want to say before we move on to the other point, which is what I've done here is sort of lift the hood of the car for you, and we're looking at the inner workings of people's minds. This is by no means what you would get if you interviewed somebody and asked, what were you thinking when I did this rhetorical strategy with you? These feelings and reactions are very quick. They're largely emotional. They're largely unconscious. You wouldn't interview a judge and have him say, like, oh, I felt uncomfortable, and then I had a bad reaction, and I got angry, and so I just rejected the whole argument. The thing that's so important to lawyers about this, I think, and really this has been a theme throughout all three panelists, is the unconscious nature of how this happens, to the point where the person isn't entirely cognizant of why they're making the decision. What happens is they have these feelings, and then the decision that they make just feels right. It feels like the right decision, and that's both something lawyers very much need to know and be very, very careful of, because once the judge or the other decision maker feels like a decision is right, they're going to look for ways to justify that feeling with whatever evidence or other arguments you have about that. Okay, so point number 2, avoiding cognitive dissonance. This is the controversial premise. If you have something that you have to argue, you want to make an argument, but it's a really difficult argument to make for whatever reason, what cognitive dissonance and psychologists tell us to do is try to think of that controversial premise as trying to get the judge to dive off a high dive. And if you start out by saying, hey, judge, go to the top of the 20-foot high dive and just, take a belly flop off, that's going to arouse a lot of cognitive dissonance in the judge. So what psychologists suggest that we do with that is break down that premise into small steps that are more easily agreed to by the judge and take the judge sort of step by step up to that controversial premise. As the judge goes up the steps, it becomes more and more comfortable for him to dive off the high dive because he will feel like now he's making a decision that is consistent with all those prior decisions. That will be a way of avoiding cognitive dissonance and getting that good feeling of the world is right because diving off the high dive is really consistent with these prior steps. The negative side of that is once you get the judge to a sort of tipping point on those steps, going down will arouse a high degree of cognitive dissonance because then the judge or the jury will have to admit to themselves that those first few steps that they took were wrong. Most people don't want to do that. I can hazard a guess that most judges would find that pretty uncomfortable. They don't like to think that they were wrong. So if you can reach that tipping point with your premise, then it's easier for the judge to dive off and accept your premise than it is for the judge to walk back down, reject those prior premises as wrong, and say, I'm not going to dive. So, of course, the trick here is how do you fashion those steps, those prior premises? And there are many, many wonderful examples out there of how lawyers have done this. But one of the best examples is a brief in Lawrence v. Texas, the petitioner's brief in the Texas sodomy case. That case was, you couldn't have packaged something better for cognitive dissonance purposes. That ultimate premise was going to arouse a high degree of cognitive dissonance in the judges. They were asking to overturn binding authority. It was relatively recent binding authority on the Supreme Court, and it involved a topic that my guess is that most of the members of the Supreme Court were probably pretty uncomfortable discussing or thinking about, which was sodomy. So it was sort of tailor-made for a high degree of cognitive dissonance, and what the advocates did in that case, now for the purposes of this PowerPoint slide, I've just sort of given you the bare bones of the argument, so you're not seeing all of the links in the chain, but this will give you an idea. They started out with Griswold, right? We know that government can't interfere with an adult married couple's private, intimate decisions. Next step, we know that this right extends to all adults, whether they're married or unmarried. That was Eisenstadt. The same freedom is at issue here for an adult couple to make private choices about their intimate relationship. The Texas law utterly destroys that freedom, therefore the law is unconstitutional. So is this a perfect syllogism? No, of course it's not. That third step is still going to be a pretty big leap. But again, I haven't given you all the nice arguments that came in between that. This is sort of the bare bones. But the idea is there, this idea that before you get to that last point, which is I want you to do something big, and I want you to do something big on behalf of a group of people that you may not be comfortable thinking about, there is this sort of step-by-step approach that starts the judges on the road to that high dive. So that's it. In conclusion, I wanted to say sort of one of the themes of my talk for you guys that I wanted you to get out of this was so much of decision making is based on emotions and feelings of rightness or wrongness. And one psychologist, Jonathan Haidt, wrote an article called "The Emotional Dog Wags the Rational Tail." To me, it's high time for lawyers to start thinking about how to get at the emotional dog, and this is meant to be a step toward that process. You know, really think about how your arguments are going to make the judge feel. Are they going to feel uncomfortable? Are they going to feel like they're being consistent? Are they going to feel like they are angry? And those are going to be the things that often will make the difference in your case between winning and losing, or, you know, getting your judge to follow you or your jury to follow you or not. So thank you very much.
I'd like to ask the members of the audience if people have questions. Jeff.
Struggling to formulate the question since Professor Solin's presentation, but essentially, is there any reason to suspect, or are there any studies that would show that judges are any different as far as the biases they would have than regular people?
I've looked at this a little bit, if I could feel it. One bias is particularly pronounced in judges, maybe more than one, but one that has been documented is something called the status quo bias, particularly for appellate judges. So the idea is, part of it's also conformity effects. If a lower court judge has made a decision, that becomes the status quo, and it takes a significant amount of countervailing evidence to get the appellate judge to deviate from that position. So this has been studied not just in judges, but in sort of interesting studies. So the most famous study is a study of health plans at, I think it was Harvard, where employees were offered the chance to get a cheaper and more comprehensive health plan if they just actually switched over to the new plan. It just required a couple forms, and almost nobody made the switch. Even though any rational actor would make the switch, cheaper and more comprehensive is very rare, right? So this idea is the status quo bias. You've made a decision, or one of your peers has made a decision. It's almost impossible to get you to deviate from it. Criminal defense lawyers who do appellate work, like Kevin and I did, we're very familiar with the status quo bias and getting judges to overturn decisions. So that's one study that's been out there, the problem of the status quo bias.
Also, Jeff Verklinski at Cornell, I think, has done numerous studies of judges. He's had access, I suppose, because he's Jeff Verklinski at Cornell, to the Judicial Conference in several years. And he's done several studies, to my knowledge, of cognitive bias and judges. And by and large, I'm going to oversimplify here, but has found that judges are susceptible to the same cognitive biases as the rest of us. They may more strongly think that they are not, but they are, by and large, wrong about that. Jennifer?
Thank you. So, Michael, I had a question for you about the policy arguments. When I was looking at your breakdown, I was thinking about the sort of structural nature of legal institutions and whether the structural idea of who is the right person or the right branch or entity to decide a question just goes into the bucket of competing policy arguments, just like substantive consequentialist arguments about marriage is good, marriage is bad, we don't care about marriage. The court should decide, that kind of thing. So sort of who decides is that a distinct additional feature of legal policy arguments, or it's just one of many arguments in the bucket? And I think actually that question kind of broadens out to everybody, insofar as I'm wondering, you know, we coach students to make what Newman calls justifying and motivating arguments, like you have to do it and you should want to do it because it's a good idea. And so at some point, does making policy arguments diminish your argument because you're trying too hard? Like you add more arguments to something that's already fundamentally sound because it's great, and every case says you have to do it, and it's super great, and then they're like, you had me at hello, right? So actually, I guess that's kind of two questions, so thank you for listening.
Let me respond to your second part first. I think policy arguments can undermine an argument. In my textbook, I talk about how the importance of a policy argument depends on how clear the law is. And if the law is clear, then there's not as much need for a policy argument. And so really policy arguments fall in those situations where there are legitimate arguments for both sides, like the examples that I gave. And at that point, the court is left to consider policy because the law really is not clear. And I think in a situation where the law is clear and a policy argument can overwhelm it, you go, why are you arguing on this policy when the law is clear? And so in the beginning of my article, I talk about when a policy argument is most appropriate. It's in those situations where the law is not clear and therefore the court is looking to make the best decision based on the implications beyond that case. Going back to your first part of your question about the relevance to this and who is the correct person to be making these policy judgments, a lot of what I talked about would apply to policy decisions in the legislative branch, but I'm focusing specifically on, and I exclude and try to limit my discussion to the judicial situation, and recognizing that a lot of cases, particularly in the appellate courts, come down to a policy decision, and those I would say more than fewer come down to a policy decision because the process of appeal is very expensive. And so if the law is clear, one of the parties isn't going to take that step. And so most appeals involve situations where there are legitimate logos, logic arguments based on the law on both sides, and it comes down to a policy decision, and then it's a question of which policy side is more persuasive.
Yes. Right.
Yeah, I can't find anything on this. What are the ethical implications of exploiting cognitive bias?
Oh, I can talk about this.
No, is there a point at which you are tricking people by exploiting a cognitive bias that you're aware of, that they're not aware of, being a jury or a judge? Okay. It's akin to disclosing contrary authority as a fellow lawyer. Is there anything out there as to what point what we're trying to do here is to tell these law students and others, these are the cognitive biases, this is how you're going to win, do this is how you're going to lose. Are there ethical implications?
Brett, I like what you said at the end there, at what point?
Right.
Because everything that we teach anecdotally to be persuasive is at some point based on biases and things like that. When we tell our students to emphasize certain things, we're actually employing the Van Restorff effect. And so when we tell our students to studies in cognitive psychology show that people are more persuaded by a credible source of information. So we tell our students to come across as being very credible. Well, all of that is taking advantage of cognitive bias. So I think your question is a good one. At what point? Where's the line to be drawn? And I think I think it's definitely a discussion we should be having, and I think it's a difficult question.
Actually, just to respond to that, I think it would be unethical not to exploit them. Because if you're going to be a zealous advocate, and the hallmark of being a good lawyer is the duty of competence. It's Rule 1.1, right? You have to be a competent lawyer, a zealous advocate. And if you're aware of these cognitive biases and you're reluctant to exploit them, it's not unlike not citing cases that could help your side.
What if the other side, the jury or the judge, isn't aware of them? Then aren't you tricking them?
Not at all. That's their own delusion. Right? Their lack of self-awareness. If they can't look in the mirror and understand their own biases, that's their problem. That's my view. And maybe there is a point at which it's unethical, but I'm not sure where that point is. I don't think I've come close to it, or at least that's my own egocentric bias.
Right. I think, just as Robert says, like in every case, there's one side that's trying to get him to make the wrong decision.
Right.
And that's sort of the way the system works. I don't want to sound glib about it, but to me, the studying cognitive bias or psychology is not that much different from saying, hey, we have an adversary system, everybody gets the same access to research tools, they get the same access to legal training, and, I'm not going to worry so much if the other side is not as good a lawyer as me or whatever. So.
I think, no? Betsy?
Why do you call credibility a cognitive bias? It doesn't seem, I mean, to me, bias does have a, prejudicial connotation, and some cognitive perspectives are not biased perspectives.
Maybe it was a poor choice of words to call it a bias, heuristic. I was discussing more in terms of cognitive bias being a broad concept of taking advantage of known cognitive reactions. And the studies show that people respond well to information that's presented by someone perceived to be credibility. And so to the extent that someone tries to improve their credibility in the eyes of their audience, they're trying to take advantage of that aspect of cognitive behavior. So maybe not a bias.
I guess I'll push back a little bit, just because I think any time we're saying that a decision maker is making a decision based on something other than the merits of the case, and that includes the credibility of the advocate, I'm sure we've all had experiences with situations in which the one side of a case had the less credible lawyer but had the better of the merits. So I think in that sense it is a little bit of a bias if the judge says, well, I like this lawyer better, she's telling me more stuff that I want to hear, so her argument seems better to me, even if we were able in some way to look at it completely dispassionately, the substance would go to the other side.
Yes. Oh, I'm sorry.
That's all right.
Okay, go ahead. Yes.
Hi, I just want to follow up a little bit on the ethical part, because I've thought about that too, and I was a public defender for a long time. And I just don't think any of these strategies ultimately change. It's like any other kind of advocacy. You have the law, you have the facts, you have the policy. What they're doing is sort of maximizing what you have. And so, the best cognitive strategy isn't going to overcome if the evidence, if your client's fingerprint is on the gun. But there are strategies, there are things that are always running in the background anyway, so understanding them helps you make choices as a lawyer, and that's what I try to tell my students, make choices as a lawyer about which way to go. But I really don't think that anybody is ever going to, lose a case or win a case entirely on a cognitive bias. That's just my...
Go ahead.
Okay, let me just throw a little bit of a hypo, going to Brett's point too. Very common practice in criminal defense. Your client had a beard at the time of the crime, or was dressed a certain way, and you have him shave. You have him lose weight. You change his appearance. You put him in a tie and a suit. What do you think? That's going to cognitive bias. Most people, jurors and judges, would assume that someone who's clean cut on the margins is less likely to commit a crime than somebody who's scruffy. Right? What do you think? Is that unethical? It happens every day. What do you think? Just a question. Make it interactive. You want it to be interactive. What do you guys think?
It's done all the time.
Well,
I think we already know what I think.
That's advocacy.
It's part of the culture, too.
Yeah, no,
And
it's what we do.
ethics is culturally defined. So.
I think it's going to go both ways. So the jury or whoever's
Yes.
receiving this can see it
as a ruse and say, well, I know that in fact this guy is not like that. And on the other hand, somebody else can perceive it as someone who, look how clean cut this person is. So I think it cuts both ways.
And that goes, Kathy, to your point about cognitive dissonance, just feeling duped a little bit.
Carrie.
First of all, thank you to all the panelists.
I thought all your presentations were fascinating. To what extent does your work in cognitive bias informs your teaching of either first-year students and perhaps upper-class students?
I teach an advanced course on advanced persuasion, and so I really do not. I have enough on my plate to cover in the first year to, even in the second semester of the first year, I cover persuasion, but I don't get into strategies in that much detail. I do get into the broad strategies like logos, pathos, and ethos, persuading through logic, persuading through emotion, persuading by establishing credibility, but definitely don't go into detail But in my advanced class, that's all it's about. It's not document-based. It's not how to draft an appellate brief. It's let's talk about strategies for being more persuasive that could apply to many types of documents and many types of situations. So I personally do very little of it in the first year and save it for an advanced seminar on persuasion.
So am I the only panelist who teaches both first-year legal writing and advanced persuasion courses?
I do.
Oh, you do? Oh, okay.
Right.
I thought you said you only taught advanced.
No.
Oh, okay.
I only teach the strategies in my advanced.
I see. So I struggle with this because I see this field as relatively new, and so I struggle with the fact that what I'm supposed to be teaching my first years is how to be lawyers out there in the real world with people, many of whom are lawyers who don't think about cognitive bias or haven't heard about it or think about cognitive dissonance. So I kind of try to hit a balance. The place where I get most bollocksed up is in disclosing flaws, because in the first year I have one semester, and I say to them, like, I need you to learn how to be able to deal with bad facts and bad law. So I sort of throw out there that there's a disagreement among lawyers about how to deal with bad facts and bad law, but I said, I'm going to make you do it because I need to teach you how to do it. So, but in terms of how much of the psychology I go into, not very much. I don't want to sound autocratic, but I sort of say, we're going to do it this way. You know, here's a very brief explanation as to why, but sadly, I don't have the time, so I do it mostly in my advanced courses.
I actually do it in my criminal law class, but only I use my students as guinea pigs. I don't teach the cognitive bias. And it goes to this idea that I think 90% of life is confidence and just projecting confidence and feeling confident, not being, again, delusional, but to some extent believing in yourself. And unfortunately, a lot of first-year students, I teach criminal law in the second semester, have been defeated by the first year. So when I get them in criminal law, they need a little bit of a boost, right? So I make a point. Every time I make sure my students, all of them speak in class, and I just have a little checklist, and I make sure that the first time they speak, I give them positive reinforcement, even if it's not a statement worthy of positive reinforcement. I find something in there just so they'll keep talking and feel a little bit better. So I think that's how I do it in the first year curriculum, just to engender some confidence, especially in students who may be defeated by their first semester performance.
Okay, last question, Tara.
My question is about writing an appellate brief, and this idea that you want to walk the judges up the high dive, but often you're starting by asserting your premise in an appellate brief, and you've got to sort of take the plunge just in your statement of the issue, or take the plunge right at the beginning. And so how would we translate that strategy into actual writing, although it seems very appealing?
Yeah, so that's a very common question that I get, because not just because of the statement of the issues, but also because of the headings, right? You have to assert that controversial premise in the heading. The hope that I have is that having asserted it, you then pedal back and sort of take the judge's hand and walk them to that premise once you get past the heading and you go into your text. We don't have a good way of knowing whether that works. The studies that I drew that from are not in the advocacy or legal advocacy realm. They're in other types of persuasive messages, advertising, marketing, things like that. But even within that, within those studies of advertising and marketing, you still have the overarching high dive premise out there: buy my product is better than the other product, before you start the steps. So that's what gave me some confidence that it could translate, even though the lawyers are even more constrained by the format of the brief to lay that high dive out first.
Okay. Thank you so much to the panelists. We're going to take a 15-minute break. Please help yourself to coffee and pastries upstairs, and we'll resume at 11:30.
And Our first speaker is Linda Berger, who comes from UNLV, and she's going to speak on seeing metaphor as an analogy, suggestions for persuasion.
Perhaps.
Maybe.
Is it okay to just say I can't go on if I don't without my theater and my little clicker is there? Okay. All right. I think I will try to use the mic more or less. So my intuitive, counterintuitive thesis today is that the same process that leads to bias also leads to imagining alternatives for problem solving. So I'm basically trying to take the positive view of cognitive bias and heuristics. And in particular, I want to talk about how some recent research into metaphor provides some suggestions, I think, for persuasion. At least that's my hope. I wanted to start with a caveat. Does this remind anybody of any cognitive bias studies they've seen or heard about? Jennifer, can you explain to us what this reminds you of?
The one I read about in Thinking Fast and Slow was how when people read words that have to do with elderly folks, they walk down a hall more slowly right after the exercise.
So this was a study that was done, very good. This was a study that was done in, I think, 1996 or so, and they told people, it was an unconnected research study, or a test, really. Unconnected in the sense that the subjects didn't know what they were being tested on. They gave them the words Florida, gray, and I forgot, bingo. And supposedly then the test subjects, when they left the test site, they walked more slowly than the people that had not been primed with these words. So this study got a lot of publicity in Malcolm Gladwell's book in 2005 or so. And the reason I'm bringing it up is because the New York Times last Sunday had an article about how some researchers tried to replicate this study and they were not able to. And the article went on to say that doesn't mean really the study is wrong. It just means that it's very hard to replicate studies. And it also means that we need to be really careful about the lessons that we draw from various kinds of cognitive science. And I try to remember that and be very humble about my own ability to, first of all, understand the cognitive science, and second of all, to apply it to something that is really not designed to be applied to. It's the people who are doing these studies are not thinking that, oh, someday lawyers are going to use this information in order to persuade people. They're just trying to figure out how people make decisions. Now, I think lawyers need to know something about how people make decisions, obviously, if we are going to be able to make conscious and deliberate choices about our persuasion. So I think the studies are very helpful, but I try also to remain really skeptical about my application of those studies and my ability to understand all the nuances. The scientists are really, really careful to say, you know, this was this study under these conditions, it happened in this one place. And they do try to do replications, and they also try to do self-correction. And I just start with that sort of as a caveat. I'm going to talk. Michael Higdon, who's also on this panel, had suggested that this part of the panel discussion today be called the intersection of rhetoric and cognitive science. So I changed it to the corner, and I found a suitably lurking figure, and I found a corner, and I found the suitably lurking figure wandering around there. And that's also just a reference to the fact that I think that because the cognitive science that we're applying hasn't really been applied to legal persuasion, doesn't really come out of legal decision-making contexts, that we need to do some triangulation or cross-checking. So what I try to do is to do some rhetorical analysis of arguments and opinions and briefs to see whether or not the things that the cognitive science might suggest are actually borne out in the things that I read. That's also because I'm much more comfortable in rhetoric and rhetorical analysis than I am in cognitive science. But I do think it helps as sort of a cross-check. That also kind of brings me to the other underlying theme of my presentation, which I said was intuitive and counterintuitive, and that is the connection between imagination and bias. The person who's quoted in this quote here is a philosopher of the mind, which I find to be a really interesting subspecialty of philosophy. And she's saying, basically,
If you just make rational arguments, you're really not counteracting biases. You need to apply your imagination to counteract biases. And because, in my opinion, it's the same process that underlies bias and imagination, that makes for a nice, coherent picture of how you can use some of this cognitive science for persuasive purposes. So we've talked, a couple of people have already talked about what one of my former colleagues calls schematic cognition, which is just the idea that we go through a lifelong process of chunking information. We develop frameworks. These are some of the frameworks. We develop frameworks for the information that we perceive. Those frameworks help us organize it. They also control or frame how we interpret the information. And I've just listed a whole bunch of the different kinds of frameworks that people have found that we have created in our brains over time as you get older and older. So this is the way Piaget, I think, said that children learn. You start with fairly simple frameworks. Categories are the simplest of the frameworks. And you go up in nuance and you go up in complication as you get more information. And the new information is added to your frameworks, but it also helps you develop new frameworks. But this process basically posits or suggests that when you get new information, you channel it into these frameworks. The frameworks then provide inferences for projection onto the information that you've perceived and now help you interpret it, and then that gets put back into a more abstract framework, or you get a new framework, or you just get a more complicated framework as you go along. If this schematic cognition in fact exists, and I think there's pretty much of a consensus that this is one of the ways in which we think, and it's a very nice, plausible, and coherent account, so I like it on that basis. If in fact this is the way that we go about thinking, the next thing I want to talk about is how that schematic cognition relates to what I think most of you have now heard of System 1 and System 2 thinking, due to the popularity of Daniel Kahneman's book, Thinking Fast and Slow. It is those schemas and embedded knowledge structures that are responsible for System 1 thinking. That's why we have System 1 automatic, intuitive thinking, where you see something and you automatically stick it into one of those categories or slots, one of those schemas or other kinds of embedded knowledge structures that you have in your head. System 1 thinking is automatic, as Kathy mentioned, and unconscious, so you can't control it, or at least it's thought that you can't control it. It's very persuasive if you can raise in the audience's mind a particular schema and they automatically slot the information that they've received from you into that category. They don't even know that you have, that because it's automatic and unconscious, they don't even know that you've persuaded them that this fits into that category. The second type of thinking, supposedly, and I do think that Kahneman and most other people who have thought about it carefully don't think of these as really two separate systems, but being along a continuum. So sometimes you've got System 1 in action, sometimes you've got System 2 in action. System 2 is the slower, more analytic thinking, where you're trying to figure out where things belong, where you're readjusting your frameworks. It still depends on frameworks, because the frameworks are the way that you're able to organize and interpret all of the many pieces of data that come into your head. They're also the way that you figure out what to do with those many pieces of data once you've got them organized into these schemas. So System 2, lawyers love System 2, right? Because this is the logical, rational mind that we all like to think that we're using all of the time. But we're not, because System 1 thinking is the thing that helps you get across the street when the light turns green. If you had to sit there and Google what green means before you could decide whether or not you could cross the street, it would take you a very long time to cross the street. So System 1 is very, very handy, and it's what we use probably 95% of the time. Was it the dean that said we make up these statistics as we go? That's probably really, really low, I would think, because System 1 is really how you get through most of your daily activities. System 2 is really, really important, though, for those times when you want to change somebody's mind, and that's where I'm going, hopefully, eventually, with this. So I wrote this article that hasn't yet been published, but it's called A Revised View of the Judicial Hunch. And what I was trying to say in that was that it's sort of similar to kind of what I'm trying to say this morning, was that these heuristics and biases have a good side, that there is a good reason to try to get judges to trigger System 1 thinking in judges or to trigger intuition in judges. But I am not talking about intuition in the sense of a gut reaction. Somebody put a headline over this article, over a little abstract of this article that I wrote that said, it does matter what judges had for lunch. And I'm saying, no, that's not what I'm saying. It does not matter what judges had for lunch, or it might, but that's not my point. My point is that intuition matters. And intuition, according to the people who have studied this a lot, is nothing more and nothing less than recognition of a familiar pattern or path. That's how this fits to that schematic cognition notion. You've got all this stuff in your head. Intuition is how you figure out that the new information that you've got fits into one of those frameworks. So intuition can lead to System 1 thinking, just slotting things into categories, but it can also lead to the more complex sort of continuum of thinking, because first it triggers, intuition first triggers your recognition of one or more parallel patterns or paths, but then it makes you, if you're in the intuitive problem-solving model at least, it makes you simulate or carry out that pattern or path to try to figure out whether or not it works to solve the problem that's in front of you. From the intuitive problem-solving model to analogy is, at least in my mind, a fairly short step. So I'm going to talk quickly about how analogy researchers have decided that we process analogies, and then I'm going to talk about how they've decided that we process metaphors, and then I'm going to try to use 3 examples that show the use of a so-called novel metaphor. So I'm assuming a number of you have probably read some of the analogy research. The book that I'm relying on is by Deidre Gentner and a number of co-authors. And she wrote an article in that book that's called Metaphors Like Analogy. So I didn't want to exactly steal that figure of speech, metaphors like an analogy. So I said seeing metaphor as an analogy. So in the current view of how analogies are processed, it's very similar to this whole idea of schematic cognition. So you have a target, the thing you're trying to understand. You have a source, the thing you're using to understand the target. And according to this current structure mapping model of how analogies are processed, it's not the features that are mapped, but the structures that are mapped. But what starts at the beginning of an analogy is that the target and the source, you match up the object attributes, you do that. Then you look at the relationships that are present in the source and the target and see if they match up. And then you also look at higher order relationships and see if they match up. It's only a good analogy, supposedly, if there is a systematic and consistent relationship among the relationships that you then project from the source to the target. So there are a number of constraints on how analogies are processed, and there are a number of constraints on whether or not analogies are any good. And I listed here just a little continuum of what we think of as analogies just to show the difference among them. The first one is a literal similarity with the K5 solar system is like our solar system. This is one where you would match up the features, the actual features of the two systems are the same, but you would also match up the relationships between the two systems. So it has both feature similarity and relationship similarity. And so this is called a literal similarity, not really the kind of analogy that we think of. The second one is the kind of analogy that we think of. The atom is like our solar system. There are a couple of matches in the features, but they're not literally similar. The atom is not literally like the solar system, so the features match a little bit, but not very much. But importantly, the relationships match up. So this is what we usually think of as an analogy. The next step down, which is what usually happens, I guess, as analogies become more complex, is an abstraction. So now you've got the source is no longer a concrete source, but it is an abstract source, a central force system. And now you're saying the atom is a central force system. You've got a feature match and a few features, very, very, very few features, and many relational matches, just like you did with the regular analogy. This just shows the sort of progression as you go along. My favorite one here, though, is coffee is like the solar system. It is not an analogy. It doesn't work unless you can figure out a way to make it work. And it's just there to show you that you have to have some matches in the features, as well as some relational matches in order to have a good analogy. There are lots of constraints on good analogies, and if you've made analogical arguments in legal briefs, you'll note that when you make an analogy, when you say something is like something, you are just asking for the other side to say, no, it's not. I can tell you all the ways in which it is not like the other thing. And that's why we like metaphor. Gettner and her colleagues did studies on how we process metaphor, and she found that we process novel or new metaphors just like we process analogies. But conventional metaphors, we just process like categories. We just slot things into categories. We don't think about it. With a novel metaphor, we try to figure out how the features match up, then how the relationships match up. And it requires us to go from system 1, slotting something into the category for a conventional metaphor, to system 2, actually scanning to see if there's a match, trying to see whether or not the relationships match up. And if they do, then we can project things from the source to the target, which is good for a lot of legal arguments if you're trying to change the way things are. If you just want the conventional stereotype metaphor schema to exist, you don't want system 2 thinking, you want system 1 thinking. So this is, the novel metaphor is when you are looking for system 2 thinking to come in. And I have to mention a couple of specifically good things about processing metaphors. And this is one of them, and I know you've all seen this before, and you know how to slip and slide your eyes and make it click into place. So you're either seeing the old woman or the young woman when you look at the picture. We did this at my law school a couple weeks ago, and there was one guy in the back of the room that was just so angry because he couldn't see both of them. He could only see, I can't remember which one he could see, but he couldn't see them both. He was just sure there was something wrong with the picture. But if you really can't see them both, you just have to kind of move your head around, close your eyes, squint, do various things, and you will see them. And this is something metaphor can do that analogy does not. Without giving you any new information, you get a completely different perspective on what you're seeing. You either see a young woman or you see an old woman, and I've given you nothing new to think about. It's the same picture. And that's one of the advantages, I think, to using metaphors over analogies, although analogies, of course, are also very good. A couple of more things before I talk about novel metaphors that I think are good about metaphor. Because in a metaphor you are really saying one thing, but you're claiming that you're not actually saying that. Juliet is the sun, and if somebody says, no, she's not, you can say, well, I never said she was the sun. I just said it's a metaphor. I just said, I can see ways in which she's like the sun. With an analogy, even though you say, Juliet is like the sun, you are actually making a statement that Juliet is like the sun. With the metaphor, you can just say, no, it's just a metaphor, it's just poetic, I'm not meaning anything. There's no propositional content. I can deny this, and you cannot say that I told a lie, which is an important thing for lawyers, I think. Deniability, I think, is an important thing. The other, sorry, I probably shouldn't have said it. The other thing about metaphor is it doesn't have to follow the same rules that analogy does, as long as we're talking about novel metaphor. It doesn't have to follow systematicity. It doesn't have to be consistent. And I think that's because we still think of it as not being, it's more of a poetic statement. It's not quite so much of a literal statement. It's not so much of a propositional statement. There's some, metaphor also is used more often in emotional and affective context. analogy is almost always used in explanatory context. I think that means that metaphor is a little bit better for carrying emotion from one thing to the next. And as I think Kathy mentioned, emotion is one of the things that I think we should be paying more attention to than we have so far. So now I'm going to give you a couple of examples of people or arguments where I think that they have taken advantage of this novel metaphor or novel characterization idea. And when I say novel metaphor, I don't mean a metaphor like a corporation is a pomegranate. That is not a good metaphor, right? Because it makes no sense whatsoever, even on the surface. So that's not the kind of novel metaphor I'm talking about. I'm talking about using a concept or a stereotype or a characterization to characterize a target that has not been characterized in that way before. So it's using a metaphor or an image or a characterization or an archetype or a story just to characterize something that has not in the past been characterized that way. So it's a novel use. Maybe it's an old metaphor, but it's a novel use or application of the metaphor. It's not that you've come up with this outlandish thing. It's that you've used this thing in an outlandish way or a way that people hadn't thought of before. So the first example is from an article by Pam Wilkins, who is a legal writing professor or clinical professor at Detroit Mercy. And she wrote this article about the use of narrative to neutralize capital jurors' implicit racial biases. And she uses an opening and closing argument in the capital case of a criminal defendant who had been convicted of murdering an informant and was a drug dealer. And so she says, you know, the master narrative here is violent crime, violent criminal, acting on his own, individual. And in fact, this young man was a Latino, so she said, you know, the stereotype that the jurors had in their heads was Latino drug trafficker and murderer. Instead of just letting that sit there, or instead of doing the typical criminal defense lawyer thing of opening up his childhood, this criminal defense lawyer came up with some, what Pam claims are novel characterizations for this criminal defendant. The first one is that he's a child of God. I thought that was, and I'm assuming that most of you think, that's interesting. So what does that do from a cognitive point of view? It's kind of a question. By characterizing him as a child of God. Pam says, go ahead. So at least you take away some of the otherness, right? We're all children of God. And Pam says it also primes this idea of fairness and justice and equality. If he's a child of God, going along with what you said, if he's a child of God, at least the jurors have been primed with this idea that they should be fair and just and not just take into account their own feelings about this particular criminal. But more importantly, what the criminal defense attorney did here was he came up with some additional characterizations that would not normally be applied to drug traffickers who have murdered confidential informants. This young man had in fact done a number of things, even when he was a child, to take care of the rest of his family, the other children in his family. He had a horrific childhood, but the defense attorney did not focus on the childhood to explain his bad acts. They focused on the childhood to explain how he had taken on this role as the protector of his extended family. He did birthday parties for everybody. He didn't spend money on himself. He spent money on his sick mother. He spent money on his cousins and his nephews and nieces. So even though he was a drug trafficker, he was a drug trafficker, a drug dealer, in order to take care of his family. Once you have that novel characterization there, if this is processed like an analogy, you go sort of feature-to-feature matching. He does have some of the same characteristics as a father protector. He takes care of his extended family. He works to take care of his extended family. He spends money on his family as opposed to on himself. And then you project the inferences from father protector back to him. If all you're doing is trying to protect your family, you really shouldn't be penalized all that much if you happen to do it in a bad way. So this is a better explanation for his behavior than even the explanation that he did it because he had a deprived childhood. Yes, he had a deprived childhood. Despite that, he became the father protector. Pam says that the defense attorney also includes in this argument another novel characterization, which is that this defendant is a first-generation immigrant. Again, the same idea that he is sacrificing for his family. He's not doing this for himself. And that novel characterization also should carry over some perhaps positive inferences that as an immigrant taking care of his family, some allowances should be made for the way he chooses to take care of his family. The next example that I wanted to use is a very different example, and it comes from a case that was in California and went to the Supreme Court, I think, around 2000. This was a citizen activist filed suit against Nike saying your advertising and public relations is misleading and should fall under the California statute regulating false and misleading advertising. This got to the Supreme Court, and then the Supreme Court at some point decided that they didn't really mean to grant that writ, so they got rid of it and sent it back. But the conventional metaphor here is one that I think, maybe 20 years ago we wouldn't have thought was so conventional. The conventional metaphor is the corporation is a person participating in the marketplace of ideas. You can see how that just gets slotted right into a category. Maybe since Citizens United, it's not slotted quite so much, but there's nothing novel about that. You've heard this over and over and over again. You know what the consequences is. If are of this particular characterization, it's automatic. There's no conscious thought. If they are a person, if this is a marketplace of ideas, then you should treat them like everybody else participating in the marketplace of ideas, and their First Amendment rights should be protected. So that's the conventional metaphor. If that's what you want, System 1, that's what you should do. And that's what everybody did, including the people that didn't want that result. There were a couple of people that did sort of novel metaphors, and they don't seem all that novel, which is why I gave the explanation earlier that I'm not really talking about novel in the sense of Juliet is the sun, but novel in the sense of this has not been applied to this target before. So the first one, corporation, is an intelligent machine. Nobody actually argued that, but a couple of commentators said that they should have argued that. The second one, some people did argue, some of the amicus briefs, that rather than a person participating in the marketplace of ideas, the corporation is just a manufacturer of products. We all agree with that part, right? But the products here are the images, the advertising campaign, the marketing tools, all of those kinds of things that are generated by Nike when it does advertising and public relations. If, in fact, this novel metaphor works like an analogy, you would match up the features of products and these kinds of things, images, public relations campaign, and you would project the inference that, therefore, if you're doing products, you should be subject to regulation to make sure your products are safe and healthy. It didn't work, but it was at least an attempt to use a novel characterization. So the last one is Plyler versus Doe, which I'm sure a number of you are familiar with. This is the case in, I think it was decided in '82, when the Texas legislature passed a law to withhold state funds from local school districts for educating students who were here without papers. The language that they used, not legally admitted, was the language that they used in the statute itself. This is, when you read this case and you read the briefs, it's just, it's like today, except the numbers are a lot smaller. The arguments are the same. The numbers are just a lot smaller. So in the Texas brief, one of the commentators characterized the Texas brief as being basically an argument that what is it that you don't understand about the word illegal? Because that was their entire argument, was that these children were illegal, and that was the end of the conversation. So the metaphor there is seeing these children, not as children, but seeing them as illegal, and that is the characterization, and that's what Texas said, and that was the end of the story as far as they were concerned. The trial court and one of the plaintiff's briefs instead characterized them, these are just the school children, right, as permanent residents. So you should see them not as undocumented immigrants, not as school children, but as permanent residents, and that changes then the rest of the argument. But the basis they had for this was that immigrants who were here with their families, so that there were children that were going to school, were likely to stay here, that they had brought the entire family here. most of the time when the whole family comes, nobody goes back. So it's different than people that just come here to work. This is a whole family coming, bringing their children along. Most of the plaintiffs in this case they were undocumented, but they were not deportable, so that on that basis also they could be characterized fairly and accurately as permanent residents. The Supreme Court majority went along with that basically and said, that just the fact that they're illegal or unlawfully here doesn't negate their presence in the state, presence being the important word for equal protection analysis. And then they went on to say, so if they're permanent residents and you don't educate them, you are basically constructing a permanent subcaste. And that does not go with the American story. And education is the way that people get out of castes in the American story, and immigrants are integrated into the American story. The majority also characterized them as innocent children, but most of the commentators thought that that was a characterization that was designed for one justice, Justice Powell, because apparently that was the characterization that won him over to the majority point of view. But this notion that you should see them as permanent residents, not illegals, and not even innocent children, but people who are going to be here forever, played in really well to this notion that you could not therefore deprive them of an education, because if you did, you'd have this permanent subcaste, and that's not the way that we do things in America. There was a lot of citation of Brown versus Board of Education to buttress that. And this very modest metaphor change, I think, in many ways, it doesn't seem very startling, but the fact that they characterize them as being people who were, for all practical purposes, going to be permanent residents seem to have had a big impact on the outcome in the case. So my ending point is basically to advocate gently and skeptically in favor of using novel metaphors when what you want to do is to change the outcome of something that would likely be decided conventionally in a completely different way. Thank you very much.
So our next speaker is Brett Rappaport. He's our practitioner, and he's going to talk about the intersection, about genre bias and legal writing.
Okay. Put on my glasses so I can read. Thank you. As I was introduced, I am a practitioner. I'm not a law professor. I'm a practicing lawyer, and the dean had talked about the dichotomy between scholarship and practical application law. I'm going to try to approach the practical application. And with that in mind, I want you to know my conclusion before I begin, and my conclusion is one very simple word: don't. I want you to put that in your head. Don't. And we'll come around and you'll see what that means. So the long title is An Introduction to Legal Subgenres and How They Shape and Are Shaped by Legal Text to Constrain Writers' Choices and Shape Readers' Perceptions. Genre is a cognitive bias, and we're going to talk a little bit about that. But before, I want to step back and talk about cognitive bias itself. Are those the same picture or different? Who thinks they're different? Come on, be honest. Are they different or are they the same? Yes? No? What do you think? Those are absolutely identical photographs. Absolutely identical photographs. That's a famous cognitive bias. You guys don't know. It's a cognitive bias known as the leading power illusion. And our brains are programmed to see parallel lines as converging in the distance, much like train tracks. Okay? So when we see parallel lines that stop before they converge, our brains convert them from parallel lines, which they are, to non-parallel lines, which they are not. That is, this doesn't fit our preconceived notions, pre-programmed notions of parallel lines. So rather than see them as they are, we fit them into what they are not. Okay? These are absolutely identical pictures. I've seen, I look at this 1,000 times, and every time I look at it, they are different pictures. Okay? but they're not. Believe me, they are not. Absolutely identical. The point being that, there are cognitive biases that if we are made aware of them, we can account for them and change our decision-making process. That's kind of what this conference is about, or some of this conference. And some of the ways that we overcome cognitive bias is we become aware of them. That's the basis for this conference. We become aware of them. We understand framing theory. We understand hindsight bias, whatever they are. And by understanding them, we can take them into account and make sure we are not duped by the fact that someone says, the doctor says, Elizabeth, you have a 90% chance of success with this surgery. And she says, I'll do it. I say, there's a 10% chance you could die. I'm not going to do it. Okay? And so if we're aware of the cognitive bias of loss aversion, the answer to do you want the surgery would be the same. Another way we do it is we have an audience for decision. The whole idea of publication, the whole idea of judges announcing their decisions is to click in that level 2. If you slow down, you have to write it out. You're going to squeeze out some of that cognitive bias, or hopefully. Last is group decision-making. Group decision-making is a classic way of trying to round out the biases that any individual has, and that's unless, of course, it's the George Bush administration. Then you have groupthink, and then that's a bias that just feeds on itself, kind of a cascade effect. But these are the three classic ways in which we try to overcome bias. Okay, I want to talk about genre bias. Now, when I started writing the topic, and I'm kind of done with my article because I thought I had to have it done for today's conference. I didn't realize I just have to talk about it. I got another 2 months to write it. So I've done a lot of research on this, and the topic really comes from an intersection of kind of 3 different aspects. First, I had a long interest in evolutionary psychology, just kind of a fun topic. I really enjoy it. I've read a lot about it. I'm a practicing lawyer, and my kids are grown and we're empty nesters, and I got bored. So a few years ago, I finished a master's degree in rhetoric. It was kind of fun going back at 50 to college and getting a master's degree, but it introduced me to this whole world of what's called new rhetoric. Now, I'd been a practicing lawyer for 30 years, and I understood ethos, legos, pathos, all that stuff. I just didn't know the labels. And the whole idea of new rhetoric really meshed with stuff that I had done and stuff that I thought I just didn't know the labels. So one of the concepts in new rhetoric is genre. Now, genre traditionally is this kind of thinking. The genre, everybody have an iPod? You have a category, you have things on your iPod that says genre. You have country, hard rock, ska. I don't even know what that is, but I have that on my iPod. And it's just categories. My wife's a librarian. She's got genres. She's got biographies and mysteries, and it's just a place to put things. All right. Well, there's a more sophisticated kind of genre. And by the way, this is like freaky. In your slide, you had, in your PowerPoint, you had this exact same slide.
I know.
Which come on. I typed road on Google, okay, and I got this picture, and I was like, this is a good picture to use for my slide, right? So, anyway, all right, so genres, the other kind, are genres as a way of thinking, as a molder of thought and a constrainer of thought. Clifford Geertz, who's a anthropologist, I believe, wrote that shapes of knowledge are ineluctably local, indivisible from instruments and encasements. All right, and it says a lot in just a few words. To me, the word instruments is texts. It's what we say, what we write. It's our appellate briefs. Encasements are genre. Okay, and the combination of what you write and the genre in which it is created, presented, and read shapes knowledge. Shapes knowledge. And the best analogy is not that a genre is like a road, genre is a road. Okay, and this is Monument Valley looking south, and the way to think of a genre is as a driver thinks of a road. It is a path to a destination that is predetermined. It is safe. It is usually direct. And you can get to, on the left there, that's the mitten, is what that's called. You could get there. That's the mitten. The way you get there is you drive there and you go around, and then there's a little booth over there, and you pay the Indians, and then you get to see the mitten from the other side. But you could get there by turning left, right at the bottom there, driving across the scrub. You could do that. And you could get there quicker, maybe, okay? And genre is exactly like that. Genre is a road. It's the way to a destination that is set, that is straight, that is well-worn. And the question is, do you follow the genre, or do you take your own path? What is the advantages of it? What is the disadvantages of it? Okay, this is my only long slide. I'm really sorry about this. But genre, from a new rhetoric standpoint, has 6 characteristics. Okay? Remember, old kind of genre categories: ska, white power music, I don't know, whatever, country rock, all that kind of stuff, whatever. Okay, that's new genre or rhetorical genre has these 6 characteristics. Genres are text and social practices that are only understandable in relation to each other. Genres develop over time. They're dynamic. They're durable. Third, genres are very complex. Configurations of formal features and thematic comment, kind of forms and norms we call it. 4, genres are learned and used as a function of situated practice within certain settings within a specific field. Can you say law school? Okay? Law school is nothing more than teaching you law students to function in a situated practice in a certain setting within a specific field. Thinking like a lawyer is learning the genre. Now, these are the elements of new rhetoric that don't have anything to do with cognitive bias. The last one, the last characteristic of genre does. Genre is described as, for speakers and writers, hearers and listeners, genre functions, should be functions, as cognitive, suppositional, and metaphoric starting point for rhetorical and interpretive action within those professional fields. All right? It is a way of thinking. It is a cognitive bias. It is how you get from reading the brief to thinking about the case to deciding for the appellee or appellant. Okay. Step back. Cognitive process. This is my little simple example of the 2 primary drivers of cognitive bias. We've learned about schemata, or scheme theory, and that's the idea that we have these templates in our head into which we fit things. Well, another one that we haven't talked about today is prototype theory. And prototype theory postulates that people categorize ideas and items and concepts based on an ideal representation. Okay, an ideal representation of that category. So it's not just that we have these patterns, but we have these templates. So if I say dog, all right, almost all of you have thought of a collie, golden retriever. I doubt you've thought of a pug, a Shih Tzu, okay? Because our ideal representation of dog is a classic prototype. The one that started the whole idea was bird. If you ask 100 people on the street, bird, 80 of them will say robin, 15 will say cardinal, no one will say vulture. Yet, a vulture is exactly, the same thing, okay? I mean, it's still a bird. Okay, so you take scheme and prototype, you combine, and you've got genre, okay? Genre is the scheme in my head by which I judge texts, and it's the prototype against which I judge them. All right. Genre is important for lawyers because it's about human decision-making. It's an ingredient in all transactional documents, and it's an ingredient in every persuasive document. Okay, so the model and how genre functions cognitively in the brain is at 3 stages. the pre-writing, the while writing, and the after writing, kind of a simple way of looking at it. But it's important to understand the cognitive neuroscience that goes behind the processing stages. At the pre-reading stage, so I'm an appellate judge, I get an appellate brief, I put it on my desk, see the judge has it on her desk, and the first thing my brain does is it retrieves the scheme in my head based on the presentation, and I know what the purpose is. Now I am primed to read what I know I'm getting. All right? If I'm going to the best example is I give my wife a red envelope on Valentine's Day. Okay? I've given her the envelope. She hasn't read it yet. Okay? But she is primed to know what it is because she retrieves the scheme from previous Valentine's Days and previous card-giving experiences with me, and she knows or expects what's in there. While reading stage. The while reading stage is recognition. The judge is reading it. My wife is looking at the card, whatever the case may be. And you are processing it within these schemas, and you are judging it against that prototype. You are analyzing the text. You're determining the purpose. The next, and it's like neuroscience research for each of these. For the last one and the most important one, this is where the persuasion comes in. Okay, this is where the persuasion comes in with the Valentine's Day card, the appellate brief, whatever it is. From the text, including the genre assignment and the enriching text, the reader now takes his genre knowledge or her genre knowledge, grafts it on what you've given him or her, and then can make the judgment, then can make the decision, then can execute, okay? And that operates on everything from a U.S. Supreme Court brief to a grocery list, all right? This is the process by which a reader goes through in analyzing a text. And it's all centered around this cognitive bias of genre. Just in transactional documents, this is, stock certificates. You could legally have a stock certificate. I could put a stock certificate on a piece of paper like this, and I could call this stock certificate, and this would be a legal binding stock certificate, okay? And if I gave that to a client, they'd look at it like I was out of my mind. You could write a negotiable instrument on a piece of toilet paper. Try and take that to the bank and cash it, okay? So we have all of these constraints, but they are also paths. They are also ways in which the reader, the receiver, processes it. Transactional documents, you have wills, you have a legal bill. Legal bills have a certain genre, a certain construction, which are interpreted by the reader, the client, in a certain way. If I wrote my legal bill like that, okay, it would still communicate to the client that he owes me $8,347.75. But I guarantee you I get a phone call saying, what is this? Okay? And if I wrote my will without all the fancy kind of stuff up here and the initials in the lower corner and all of the genre that exists in it, it's not going to be accepted. Litigation, persuasive documents, U.S. Supreme Court brief. The genres in the U.S. Supreme Court are so constrained that the color primes the judge. The color primes the judge. It's sitting on Justice Scalia's brief. Well, he doesn't read briefs. But on Justice Roberts' desk, okay, he's going to look at the colors, and he's going to know what to expect based on the color. Based on the color. I assume that memorandums of appellees are orange. Reply briefs are orange. Same thing with a complaint. Okay. Here's the main point. This is the takeaway for you students. Breaking the genre. Breaking the genre. Should you or should you not break the genre? I have now told you that there's this road that constrains you, ties you up. All right, well, this is a traditional narrative. Traditional, the best example, Wizard of Oz. Wizard of Oz starts at the beginning. You have exposition. You're introduced to Dorothy, Tin Woodman, Scarecrow, Cowardly Lion. You're being exposed to him. You have rising action, the scene in the forest with the apples and all that kind of stuff. It builds and builds and builds with the conflict. You come to the climax, When they throw the water on the witch, melting, right? Okay? You have falling action. She goes back to the wizard and everything turns out. Classic genre. You've seen a million movies that fit this genre, and you get validated every time you go. Pulp Fiction. This is the plot line for Pulp Fiction. Okay? All right, who saw Pulp Fiction? Have you seen Pulp Fiction? Breaks every genre. The main character gets killed in the middle coming out of the bathroom. Like when that happened, didn't you say, the hell's that? Right? Did you say that? Yeah, absolutely, right? Tell me that. Anyway, you have down at the bottom, you have this plot line that is just all over the place. What? Okay? Now, Quentin Tarantino won Director of the Year, Movie of the Year for Pulp Fiction, precisely because he broke the genre. Now, let's talk about breaking the genre as lawyers. I had a brief. This was a few months ago. It was a child custody case. Father had lived in California. He got the kids moved from Illinois, and the mother wanted them back in Illinois. The trial court in California ruled that the kids should stay with the dad, even though that wasn't their home. But he felt that the mother was not as good and as structured of a parent as the father, and therefore the kids stayed in California. So we wrote a brief that the trial court was wrong. And the whole theme of our brief was the kids should be home. Even if it's not as perfect, even if mom's not as perfect as dad, they need to be home. And so in our brief, we concluded it with this. Family courts frequently and rightly talk about the importance of stability of the child. Children talk about it too. A child's home is his source of comfort and stability, and a collection of poems written by children entitled Home Sweet Home, Michael, age 9. Said it simply, you see the poem there. My room is blue, it's real and cool, it keeps me safe at night, I never fight. I ride my bike, I like a kite. But most of all, I like my room. Okay? Ottawa's Tanner's home, it's Darren's home. The children should have stayed there unless there was demonstrable detriment alleged to prove it. Here, the trial court chose not to apply the detriment standard. The kids should go back. I broke the genre. This is what happened. I got whacked. Okay? In arguing, the court erred in applying the detriment standard. Guyon, that's me, relies on secondary sources, even poetry, on the importance of stability in children's living environments. Indeed, blah, blah, blah. Here, the court described it. It remains, however, that Guyon's argument addressed in court to follow legal precedents we find nowhere. Get out of here. Who do you think you are breaking my genre? Okay? So, Chief Justice Raymond Chandler wrote in 2008 the following dissent. North Philly, May 4th, 2001. Officer Sean Devlin, narcotics, strike force, was working morning shift. Undercover surveillance, the neighborhood, tough as $3 steak, Devlin knew. 5 years on the beat, 9 months with the strike force. He made 15, 20 drug busts in the neighborhood. The issue in the case was whether or not the context of the neighborhood could be taken into account in a police officer in determining whether there's probable cause. Okay, so if this is happening in a bad neighborhood as opposed to, a wealthy suburb or something, could you take it into account? And this is what Chief Justice decided to write the statement of facts. Clearly broke the genre. Now, it was interesting that it was in a dissent. Okay? Justice Kowalski out of the Ninth Circuit. I've got a couple of copies of this I'll hand around. I'm almost done. Here's a copy of the opinion which it's fascinating. In this case, the defendant, Mr. Ramirez Lopez, was a Mexican immigrant who migrated illegally across the border. He was arrested along with about a dozen others, and he was charged with being a coyote, being a guide, which was 20 years in prison. And when he was found with the other people, the INS interviewed a bunch of them, and they all said he wasn't the coyote. He was just one of the migrants. Okay? Well, the INS decided to deport all of those witnesses. Okay? He was then charged with being the coyote and convicted. At trial, Tried to introduce the fact that the government had exported all of his witnesses. Not allowed. Tried to argue that the FBI's notes, or the INS's notes, of the conversations exonerating should come in. Nope, hearsay, can't come in. Okay? Went up to the Ninth Circuit. Two judges of the Ninth Circuit wrote a brilliant opinion affirming it. Check, 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 check. Comes to Judge Kowalski. He writes a client interview. Okay? Goes on and on. One, I got good news and bad news. Okay, I'm ready. Give me the bad news first. The bad news is the Ninth Circuit affirmed your convictions. You're going to spend many years in federal prison. Oh, man, that's terrible. I'm so disappointed. But you said there's good news, too, right? Yes. Excellent news. I'm very excited. Well, here goes. You'll be happy to know you had a perfect trial. Okay? And the opinion goes on and on and on with this dialogue. Okay? And you know what happened? Fascinating. Okay? The U.S. Justice Department voluntarily vacated the conviction, okay, based on the dissent. Now, they never said that, but it's pretty well acknowledged that this dissent was so powerful, so compelling, that it convinced the U.S. Justice Department to drop a case that they had won at trial and on appeal. So, the question for you is, do you or don't you break the genre? Do you or don't you break the genre? Well, genre is clearly a bias. It's a cognitive way of thinking. It binds and constrains the writer. It channels the reader or the listener. And so the question is, what should you do? What was the first thing I told you? Don't. Thank you. Unless you're Judge Kowalski, and then
right,
you're...
or a judge. We're really glad to have Michael Higdon here from Tennessee. He's had the flu. He flew in this morning, giving Marilyn and me panic attacks, but he made it, you know. And he's going to talk about the intersection of cognitive bias and rhetoric. In just a second.
Great, thank you. I'm sorry, I wasn't here this morning, so I don't really know what type of audience I have. How many of you teach legal writing? Oh, good, so enough that this won't bore you if I talk about this. I want to tell you about why this topic is important to me and then why it should be important to you. When I started teaching 9 years ago, maybe like you, I was very insecure about, well, I was very insecure about a lot of things. But one of the things I was really insecure about was there were times in writing I would see things and I would think, I think this is wrong, this feels wrong to me, or I think it should be this way instead. But I wouldn't really know why, and I'd have to ask myself, is that just some personal preference? So a lot of my research that I've done in legal writing and publishing that I've done has been on trying to get to the science behind those things so that I can say to the student, here's why you shouldn't do that. Right? There's something to back it up. And that's what's led me to what I'm going to talk about today. Specifically, what I started realizing early on when I would grade papers, and I grade holistically. I mean, I read it through the end, and I sort of, what's my gut grade? I mean, I go back and adjust, but gut grade. I found that I was giving higher gut grades to those papers that I just more easily got through. We've all read the books or anything where the pages just seem to turn themselves, right? Even over papers that were better substantively, I preferred those papers. So what I've been curious about is how it is we read. What are our biases when it comes to reading? Because anytime we have a bias and the degree to which things are consistent with that bias, we're going to like them more. So that's what I'm going to talk about today, how people read and how, when we teach legal writing, we should be aware of that to help our students. The role bias plays in reading, it very much plays a strong role. We've talked a lot today about schematic cognition and type 1 thinking. When we approach a text, we don't just approach it as bare letters. We bring in a whole host of experiences with us, and certain things get actualized, and we have certain preferences for how we like to see things go in the text. Now, everybody reads, but you have to think about the legal reader. And I really stress this in my classes because I think it all begins with who the legal reader is. And I think that's a unique individual. I have a picture of Judge Judy because that's who I always picture as my legal reader. And there's two qualities I ascribe to the legal reader. One, hypercritical. Just because you tell them something, that means nothing. They're going to actively question it over and over and over and over. Two, and this is what most of my presentation is getting at today, impatient. What's the bottom line? What's the bottom line? What's the bottom line? I read all the time. I don't have a lot of time to read this. If you've ever watched her show, very impatient and very hypercritical. So if we know that, then we're going to want to write our papers to someone who can get through the paper more quickly. And what I'm going to talk about today is the word and sentence level. And so why would I focus on words and sentences? Well, some of these are obvious. One, words and sentences are what make up a prose that we write. We don't have to have a certain set of sentences or a certain number of paragraphs before this bias is going to kick in. It starts at the word and sentence level. Also, as we know, legal readers rarely read the entire document. If you've ever taught legal process 2, legal writing 2, it's difficult to make the students understand. They're not going to start at the title page of your brief and go all the way through. That's why you have to repeat some stuff, right? Because they may only read parts of it. And they may only read sentences. And they may read nothing, right? And words and sentences have the potential to persuade. We know this. Just some examples. We're not going to talk too much about this. 9/11. If you use that, that carries with it a whole host of stuff. A whole host of stuff. Probably different to the different individual, but a whole host of stuff. Sentences. Mr. Taylor believed in corporal punishment. His son frequently came to school with bruises. Those two things may have nothing to do with one another, right? But sticking them together with a semicolon is going to make the reader draw some inferences. So we know there's persuasive impact, but what just in the way we read the words? What's the impact there? So let's talk about word recognition. And I'm going to talk about two aspects. One, eye movement, and the second is context, which involves priming that you've heard a lot about today. I have this image here because this is called the Stroop effect. Right? What's the color of this word? We really want to say blue, right? And even if you don't, you have to stop for a minute and think about it. It shows that the letters themselves don't give you meaning. You do take in outside stuff. Eye movement. The studies in this area are just fascinating because what they often do is they give people strings of words or letters, and it maps where their eyes go, where their eyes stop, where they can move more quickly, and it lets us know what sort of sentence structures and what sort of words people prefer. And here's the things that we've learned. Rare words are fixated longer than common words. Words that are predictable in the sentence context are fixated for less time, and the fixation time on a word is longer when it's preceded by a rare word. So throwing in a rare word not only slows the reader down for that, it speeds them up even more. Before I move on, let me just say, why the need for speed? Right? Because that is sort of my basic point. Why the need for speed? One, as I've already said, people want to get through the document quickly. They don't want to have to reread it. An analogy I've used before when I've written about this and talked about it is rides at Disney World, like It's a Small World. If you've ever done that ride, you get on a boat, and the boat just keeps going, right? And somebody very smart has calibrated that boat, say this is how much time it's going to take to see everything, right? The document should feel the same way. You know, at no point in It's a Small World do you say, you know, I'm really confused. What the hell's going on? Can we turn around and go back and see, or the Europe thing just didn't make sense. Let's go back. The document needs to be the same way, right? And speed helps us do that. It helps us get that steady pace through the document. So what do these principles sort of mean for legal writing? A few things. The first one, I often encounter this with first-year students, you may too. The student who thinks to show that I'm smart, I need to show how rich my vocabulary is. Now, instead of just saying you can use plain language, you can say, look, that's a rare word. That's going to slow down the reader. And is it fine to slow down the reader from time to time? Yes. You're going to see in a bit, sometimes you kind of want them to slow down a little bit and pay more attention. But when the reader is consistently slowed down, sentence by sentence, at the end, they're just going to have that gut, visceral reaction of, I don't like this paper. Proper punctuation. All the sentences I'm giving here today, I didn't put little footnotes saying where they came from. None of them are mine. They're all taken from studies. Okay? But look at this one. Since Jay always jogs, a mile seems like a short distance. When subjects were given that, the word seems, very common word. We know what it means. Nonetheless, eye movement test shows that their eyes really fixated on seems because it was unusual. The sentence structure was unusual with that word. So it's not just whether the word is known, it's also how it's used. Passive voice. You know, we do tell students, there's times you can do it, but you want to avoid it. This is another reason. Studies show the human brain tends to expect subject, verb, object, subject, verb, object. If you invert them, you're going to slow down the reader. You might want to. Or there might be other benefits, you know, hiding a subject. But if you do it too much, the reader's going to be slowed down consistently. Active verbs, we tell students to put the action in the verb. Often that active verb is going to be somewhat of a rarer word. Now this might be a moment, the next two might be a moment where you want the reader to sort of, not slow down in a confused way, like I don't know what's going on, but slow down and savor what's going on, because you want them to pay more attention to that. Active verbs, if rarer verbs, would have that benefit, just as specific language would over general language. Right? Often in facts, if we have a very persuasive story, we want to be very specific so that they can relive the story. Specific words, if rarer, would make them savor it a little more, not from a confused standpoint. The second one is context and priming. Words by themselves have meaning, but words in conjunction with others have meaning as well. This is an example we see a lot. That thing in the middle, if you took away the 12 and 14, you wouldn't even hesitate saying that it's B. Took away the A and the C, you wouldn't hesitate saying it's 13. With this, we're a little confused, right? Because we do take contextual cues from this. Priming comes in a lot of forms. Has anyone done a priming test this morning? Did they do one?
We didn't know.
Okay, I'm going to do one. You've probably heard it, but do it with your students. It's fine. Okay, I'm going to ask you 2 questions. Just shout out the answer. You got to do. Can't think if you think you're cheating. Okay. What color is this? What do cows drink? Yay! First question, what do cows? What is the color? White. Then you heard drink. Then you heard cows, and you said milk. And before you say, well, baby cows do. I didn't ask you about baby cows. I asked you about cows. Right? We know what priming lowers that. When we go to our mind to retrieve an answer, we have this huge body of data. Priming influences narrow it down to a much smaller subset. You heard white, drink, cows, milk got very heavy to the pile, and so it's very easy to just grab it right from the front. Words can do this as well. For example, studies have shown one thing they do with word recognition is they will flash a series of letters before the subject's eyes and say, let us know if this is a word. And they'll measure how much time it is before they say, yes, that's a word, and then that's a word. The word doctor. They showed that to people. Look how long it took for them to recognize the word. If preceded by the word nurse, much faster. Right? Nurse, doctor, much faster. So what does this mean? Well, we can use this. If I said earlier that rare words might slow the reader down, you can ease them into it with some type of prime. The first example. The defendant is an expert on boats. Specifically, he's an expert on the English punt. English punt, unusual word. You may think, I don't want them to spend too much time thinking about that. I just got to throw it out there. Boats narrows it down for me. So I can just move faster, keep my eyes going. But again, sometimes you want them to stop and just savor a little bit. The second one. On the first day of work, the plaintiff received a scythe. She was to use this implement, which consists of a long blade attached to a wooden shaft to cut grass. If you're using that from the standpoint of, look at these archaic tools they were giving this person to work with, the word scythe, pretty unusual, going to slow them down. Right? I did the opposite there. I wanted them to slow down. Now, if you ever tell your students this, they may come back with, well, I want to slow them down throughout. That's why my paper's like, you can't do that. You have to be selective. Only every once in a while. And the last one, we know this as well, and we've had some conversations about word choice. Another part of priming is just affective priming, just feelings. In television, for example, soap operas. You know, soap opera often goes to commercial with this awful thing. Someone just died, and there's that music, dun, 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 and the people have feelings. Studies show that people watching the show will carry those feelings into the first commercial. So advertisers don't want to be that first commercial, right? Unless it's somehow related to that. So it's sort of creating their, just how they feel about things. The same thing here, the child and the juvenile. I sometimes ask my students to write Goldilocks and the Three Bears from the standpoint of the bears persuasively. And they always quickly change Goldilocks to the juvenile, because it sounds like juvenile delinquent or something like that. One even said the hood. I think that's too far. Next I want to talk about sentence processing, because we don't just read words in isolation. We read them as sentences as well. And there's 2 things I want to talk about here. The first is parsing. That's just how we read a sentence. And the second is the role that our inner speech plays as we read sentences. There's 2 approaches to how we read sentences. Well, there's 2 approaches to determining how we read sentences. And they're I don't see any sort of agreement between them at any point. One is serial theories, and the other is parallel theories. And what a serial theory says is that as soon as we see a sentence, we start reading, and at some point we commit to a syntactic structure. We guess. I think this is how this sentence is going to go. And we keep reading from that expectation until the expectation is violated, if it is, and at that point we switch to another structure. Now, to guide us in choosing what that initial guess is, and notice we are guessing. We don't read to the very end and say, oh, that sentence said X. We're guessing as we go. There's two principles. One is minimal attachment, and the other is late closure. Minimal attachment just basically means our default will be the simplest sentence structure. We won't assume there's going to be noun clauses and verb clauses. And this is an example from a study. Sally knew the answer. If you started reading, Sally knew the answer, you would make an impression about what the sentence was saying. If you then read, Sally knew the answer by heart, and Sally knew the answer was wrong, subjects read the first sentence much quicker than they did the second one, because they assume it's subject, verb, object, subject, verb, object. In the last one, it wasn't that she necessarily knew the answer, but she knew the answer that someone else said was wrong. There's more going on than just the words. So this comes up a lot with students. If I were to write that, I would say Sally knew the answer. Sally knew that. As soon as you put the that in there, students often are curious about the that. And I say, if it helps to resolve ambiguity, that's the answer. But notice under minimal attachment, we will default to the most simplest structure. Late closure, we tend to assume that each word goes with the immediately preceding words. We don't assume there's been a break or a pause unless we see some punctuation. Back to this one. Since Jay always jogs a mile, seems like a short distance. Notice we put a mile with jogs. That would be our instinct. Jogs a mile. And really the sentence was supposed to say, since Jay always jogs a mile, this seems like a short distance to him. Notice that once we put the word this in, we put a new pronoun. Now we start putting the seems with the previous pronoun. Before I move off of this, one more point. Context does matter in this regard, then. So it's very easy to talk about sentences in isolation, but you also have to think about preceding sentences. And this is one from another study. The burglar blew open the safe with the dynamite and made off with the loot. That's a sentence that's pretty easily processed, because our expectations are met. But what the study found is if they prefaced it with this sentence, the homeowner possessed 3 different safes. Now the sentence slows down quite a bit, because they would read it as the burglar blew open the safe with, you would think with is going to qualify which safe. It's going to narrow it down to which one of the 3. And it's with the dynamite. You may think, who cares? Why do we care about this? Because under any of the theories, no matter which one you want to go with, the reader does have expectations early on. And if those expectations are met, they can keep reading. If the expectations are violated, they have to change oars, right? And they're probably going to have to go back and reread the sentence and figure out what's going on, right? Even if grammatically correct. So again, if our goal is to sort of get that reader just to go through, just like the boat, we want to think in terms of what the reader is going to expect when they read the sentence. Now the parallel theories, what the parallel theory says is that instead of immediately choosing, this is what I think the syntactic structure of the sentence is, and committing to it, we have preferences. We read it and we say, I think the syntactic structure is going to be this, and I'm going to rank that as my number 1 priority, but I have some other priorities in there as well. Like, I'm leaving open room for things to change. People who have supported that this is the way we process have used examples like this. 2 sentences. As the woman edited the magazine, amused all the reporters. As the woman sailed, the magazine amused all the reporters. The exact same syntactic structure. It took people longer, however, to read the first sentence than it did the second. Now, if they had truly just committed to exclusion of all other sentence structures, it would have been about the same. But the fact that in the second one they could make that transition a little bit easier shows that they were at least leaving some room for an alternative explanation to the sentence interpretation. Inner speech. Children read out loud, we tend to not. For a long time, researchers were curious what's the role of inner speech played, and it plays quite a few. One, it allows us to read much more quickly, because we're not sounding out every word in our head. Right? We can skim much more easily and read. The other thing it does, though, is it preserves in our mind the order of the sentences and the order of the words, so we can keep track of context. Right? When we come to a new sentence, okay, here's what's been going on so far. We can hold that in. Here's the thing, though. people have different reading spans. And a reading span is typically defined by how much text you can read and still remember over 50% of the last word of each sentence. That's usually how they test it. People with longer reading spans, meaning they can hold more text in their head, are much more sensitive to ambiguity and unexpected things. And I'll give you some examples. This was an interesting study. They gave people these sentences. The evidence examined by the lawyer shocked the jury. The defendant examined by the lawyer shocked the jury. They had people who had high reading spans and people with low reading spans. When given the sentences separately, they read them both the same. When they put the two together, the people with the high reading spans read that second sentence much more slowly. And the reason they surmised that they did is because they thought the first sentence was setting up sort of a parallel structure. The evidence, the inanimate thing that was examined by the lawyer shocked the jury. The second one, the defendant examined. Defendant, we could mean the defendant that was examined. We could mean the defendant that did the examining, right? Once we were sort of primed with that first sentence, it made the ambiguity much more apparent in the second sentence. People with low reading spans still read them the same, right? Because they're not holding as much in their head. They're not holding as much contextual cues in their head when they read the second one. Here's another one. The experienced soldiers warned about the danger before the midnight raid. Folks with high reading spans read that first sentence much more slowly than people with low reading spans. Because people with high reading spans knew from the very beginning that it was ambiguous. The experienced soldiers warned. You could mean they did the warning or that they were warned. They read it very slowly, and where they were most slow in reading the sentence is when they got to the word that resolved the ambiguity. People with low reading spans, no change. No change between that sentence as an ambiguous sentence and that sentence rewritten to be unambiguous. Presumably because people with lower reading spans aren't relying on so many contextual cues. They'll read the whole sentence and then process it. Now, I think this is probably the most fascinating thing that I've included today, because I think there's a whole series of research that could be done here on, if you are a law professor, you've probably found moments where you're like, why are you reading like this? Why are you not picking up on these cues? It's probably because their reading spans are a little bit less than your reading spans, right? Or just experienced lawyers, because you know to become a lawyer, your reading has to pick up. Right? So sort of a disconnect from that. But what does that mean in the meantime? If we're writing to a legal audience, and again, it's all about the legal audience, probably going to have a pretty high reading span. So ambiguity is going to be even more shocking to them, even more of a big deal. So even though we're talking about the sentence level, students have to be much more in tune with the overall document than they probably are. Okay, conclusion. I like this picture because just as humans, just as we think of a horse with blinders to sort of narrow their scope and what they look at, humans have natural blinders as well, just as they read documents. There's certain structures that we prefer, certain things we expect to see, and if we don't see that, we're going to be slowed down or either put off by the entire document. It would behoove us as lawyers and as law professors to teach our students about that so they can try and match their text to it in order to make it more palatable to their audience. Thanks.
So we have a few minutes for questions, if anyone has any. Give you a minute to think about them. What? Yeah, okay. Michael?
For Linda.
Okay.
Linda, when you were talking about the difference between metaphor and analogy, one of the examples you gave was Juliet is the sun, and Juliet is like the sun. Where does simile fit into that process?
Oh, I think in the way that analogy researchers look at analogy, it is a simile. It's, us lit folks think that's a simile, but that's exactly the same thing. So that was a nice, easy question. I like that.
Any other questions? All right. Well, thank you very much.